Good morning, my little couch potatoes, and welcome to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for some dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blankets, some delicious snacks, and get ready to watch court with your internet besties. That's me. This is Couch Court with Llama. Good morning, everybody. Oh my gosh, I've missed you all so much. I had a wonderful weekend. I hope you guys did too. Good morning, but we'll go over that in a few. I'm going to say good morning to everybody in our live chat. Hello, 80s music fan. Good morning. Hope you had a wonderful weekend. Inquisitive room. You're here for a bit before you go to work. Oh, that's right. You're back to work today. I'm so sorry. But good afternoon for you, I suppose. Hope you're doing good. Teresia, good morning. Good morning to you, babe. Pilula's mom, good morning. Good morning to you. And Cindy, good morning. Good morning, babes. Hope you're doing great. Oh, I had a very nice weekend. I got a lot of stuff done, got a lot of stuff not done. During the week, it's by the time I'm done streaming, my brain is just shut down. And apparently this weekend, it was like, oh, you're not streaming? Let's think about everything all at once and try to make all these plans. But then it gets all tangled up. And then you're left with just some ideas that are a mess to sort through. That's my brain anyway. But Saturday, I had a good time. Saturday, we watched the new Sherry Papini documentary over in our Discord, The Courtyard. Ooh, and some of y'all were there. Inquisitive Room, Pilola's mom. There's a bunch of us that watched it together, and it did not do that woman any favors. It did not do her any favors. I still think she's a liar that lies, and she's not going to convince me otherwise. Okay. There's a reason why the FBI's only charge her with lying. So I'm just saying. Just saying. Anyway, it was a great time. It's so nice to hang out with everyone, outside of here as well. Excuse me, I'm thirsty. It was fun, wasn't it? It was great. We had a little hiccups at the beginning, but we got it worked out. That's the thing. We always try to get it worked out. Anyway, so that was basically my weekend. Oh, well, yesterday I did stream to our members only. I recorded my Diddy episode from Friday because I didn't get around to it. So I recorded it yesterday and let the members, in on some behind the scenes. They got to watch me record the whole thing. I don't know if it was interesting or not, but we did it. Some people I know found it interesting. That's just one of the many things that we're looking into doing for our members. This Wednesday, we have a members only as well at 7, and I think it's going to be a good time. And well, I can't say much about it yet. I got to wait till plans are confirmed, but it's going to be a good time. Now, you guys, so rumor has it that the defense is going to be resting tomorrow. And by rumor, I mean that's what Karen said. Okay, so they only have Dr. Well, hold on. If I remember right, Dr. Wolf is still on the stand. Dr. Wolf is still on the stand. I think Jackson is in the middle of his redirect or nearing the end. Then Brennan will have his recross. But then we're going to have Dr. Rentschler, who's Dr. Wolf's partner. He's going to be focusing on basically the injuries to John. He's a biomechanical engineer. He's the equivalent to Dr. Welcher. It's interesting. It's interesting that their names are very close, right? Rentschler, Welcher. Very interesting. I just put that together. So I think, and I really need Dr. Rentschler's testimony. I don't need it, but I think some people might need it based off of what we've seen with Dr. Wolf. All right. So he did like the accident reconstruction. We saw the dummy arms and everything. And it did show, however, that an arm could bust a tail leg, right? But we need somebody else to be like, okay, but he'd have a jelly arm. So that's what I'm expecting Dr. Rentschler to say. And then they do have another witness. Ooh. forget what her name is. Dr. Lapsoda? Yeah, something like that. I don't know. Somebody check and help me out on that one. I don't remember what exactly she's there to testify. I think she's an ME. I think. I don't know. Anyway, so that's all they have. Yes, you're hoping they call the dog trainer. You know who else I was surprised that they didn't call was their own data extraction person to like combat Whiffen and his whole thing. So it is kind of weird. I don't think that's who the other woman is, just because they're a doctor. You know, they can be doctors of anything. So I don't know what that's about. Good morning, Simone. Good morning. Hope you're doing great. You know, yesterday when we got off at Diddy, I had seen your comment that was like, oh, it's raining in Ohio. And it wasn't raining here yet. And then as soon as I got off, we just got this huge downpour. I was like, oh man, Simone tried to warn me. So anyway, I do think the defense is going to rest tomorrow at some point. It could be at the end of the day on Tuesday. I'm thinking with Brennan, you know, his cross, and you know, Dr. Rentschler is, you know, going to throw a wrench in his plans. See what I did there? Oh, it's too early, Llama. It's too early, and it's a Monday. What are you doing? Let's see. Hold on. Good morning, Anne Marie. Good morning to you, and welcome. Welcome. Hope you're having a wonderful morning. Buffy said they decided not to call the data guy because they feel like they got what they needed in. Okay. That's, I mean, for me, yes. But for people that might be feeling a different way, ooh, it's a risky little game. I don't know. And the reason why I think that is because also Ian Whiffen, their data guy, and what was her name? Dr. Hyde, you know, they were towards the beginning of the trial. And so I don't know if people are going to remember how questionable some of that was. Cindy says, did the defense ever try to find Chloe? That's a good question. I think so, but I'm not the right person to ask on that. Somebody in the chat will definitely give you an answer to that one. I think they tried to find her. There was teeth prints, but then there wasn't. Apparently she's a dog going by the name of Cora now in Vermont or something. I don't, if that's even real. No one knows. No one knows. Buffy says, and they didn't want to confuse the jury anymore with complicated things. I think it's too late for that train. Brennan has done quite the job of making it confusing. And good morning, Buffy. Good morning. Now, excuse me. So the defense is going to rest. Then the prosecution is going to have a rebuttal. I don't know who they're going to call on their rebuttal witnesses. I'm assuming it's probably going to be Dr. Welcher, because they paid a whole buttload of money for him, and Aperture. So maybe him. I don't know who else they would possibly call as a rebuttal witness at this point. So I think between that and then there's going to be closing arguments, and then it goes to the jury. So I think this is going to go to the jury like Thursday, Friday-ish. So I think the jury's tired. I think I am. I don't know why I lie to myself and say, you know what? You're excited for Brennan to cross just so you can see it, right? And then 3 minutes in, I'm like, nope, I was wrong. I don't want this. I don't want this at all. So we'll see. Linda 4K, good morning. If they call Welcher as a rebuttal witness, can they call Dr. Wolf and Dr. Rentschler as rebuttal witnesses to him? No. So only the state gets to do rebuttal. In all these trials I've watched, Massachusetts seems to be a weird wonderland. But as far as I know, only the state gets to bring rebuttal witnesses, which is what it is, I suppose. So Oh, they have the dog bite person for rebuttal. Okay. Okay. Oh, I'm sorry. You heard. Oh, I'm sorry. I missed whatever this was in response to Inquisitive Room. Sorry about that. Oh, maybe this is Linda here giving you an assist. By the way, Larry, the DUI guy, was there all day for testimony. He says most of the jury is sick of Hank and they know he's a gaslighter. I mean, we'll see. We'll see. I mean, I'm over. If I was on the jury, I would be over this guy. He's something. Okay, he's something. And now they all have to do their jobs, and I respect that. They very much do, but he also goes about it in not the greatest way. So if she allows a rebuttal, if she allows, are they not guaranteed one? Y'all, I cannot wait until we watch a regular trial together. Oh, I hope Jackson. I think Jackson will do the closing arguments as well. I think he's the best orator out of all of them. Unless he's good too at that, but I just feel like Jackson, like that's really his. He's very, very good at it. And I imagine that's from being a prosecutor for many years, right? So I think it's going to be Jackson as well, Simone. So before I go on with my next tangents, make sure you like this video, please. Subscribe if you haven't yet to the channel. Hit the notification bell so you never know when we go live, because we got a lot going on this channel, not just with Couch Court with Llama, but lots of other things as well that you can find there. And share on social media. If you have social media, share this video and be like, hey, guess what? This is where all the cool kids are hanging out today. Come join us. And I would appreciate that very much. It's all free. So that's nice. Let's see. Buffy says, oh, I just thought that was a misspelling. Buffy, I'm sorry, babes. She has to allow a rebuttal? What? That's interesting. Okay. Inquisitive Room says, Larry said they put their heads in their hands when Hank talks. This trial is unique and not in a good way. Bev makes the rules up as she goes along. I mean, that would be something, but this is crazy. This place is crazy. Linda for okay says, I sat on a criminal jury with a prosecutor and a judge like this, and I'm going to tell you, I stamped it with reasonable doubt because hiding evidence for me does not work. I got a whole lot of reasonable doubt in this case as well. And Linda 4K, I don't know if you know this, but I have a show called Couch Confessions. Yes, another one. I have lots of them here. But that is where I interview members who have served on juries or in the legal realm of things that we talk about here on this show. So if you're ever interested in sharing your story, you can email me at Tara, Tara, at TCWmedia.com. And I would love to hear about your experience, because they vary so much from place to place that no one person's going to have the same story as somebody else. And I love hearing people's stories. So a sir rebuttal is a rebuttal to the rebuttal. I've never seen a sir rebuttal before then. I'm not saying they don't exist. I've never seen one. That's interesting. Thank you. Thank you, Buffy, for dropping all the knowledge this morning. Appreciate you. Simone says, well, will Bev now change the verdict sheet to add not guilty, or will the CW continue to make stipulations? That's a good question, Simone. All right, because I heard that there was some problems with the jury form in the last trial. It was a little confusing from what I've heard. I did see it, but I don't remember what it looks like now that I think about it. But anyway, they are going to probably argue jury instructions. That happens with every trial. That's not abnormal. Whether or not she'll do it in front of us, who knows? She hasn't let them argue anything, really. But I imagine she's probably going to want to keep them the same, because if she doesn't, then she looks like an idiot from the first trial. So I don't know. And you know what? That apparently the jury instructions was a big deal for the jurors. So from the first trial. So I don't know what's going to happen. Linda says the prosecution objected 49 times during Dr. Wolf's testimony and sustained all 49. That one should be yanked off of the show. Look at you keeping track. I love that. I love a stat counter. Inquisitive says Larry explains. Sorry for being a Larry Gerby. I loved you guy, aka Attorney Larry Foreman. He goes by that now instead of the DUI guy. I very much enjoy him. So question, what are we going to do after Karen Read, right? Because it's probably going to the jury by Thursday or Friday. Thursday at the earliest. I mean, if it goes Wednesday, that'll be mind-blowing. It very well could, because I don't know how they do things in this courtroom. It doesn't make any sense. Well, here's what we're going to do. All right, so right now, starting last Thursday, Lori Vallow-Daybell is on trial right now for the attempted murder of Brandon Boudreaux. Now, there's a good chance that trial is going to be over by the time we get caught up in it, depending how this week goes. But either way, even spoiler alert, she's probably going to be found guilty. If you don't know who Lori Vallow-Daybell is, it's not much of a spoiler. But it's going to be a very short trial, and I would like to watch that with all of you, because what's interesting is, like, that should actually be one of the craziest trials you watch, right? Because Lori is representing herself, which I love pro se defendants. Don't ever go pro se, okay? Don't ever do it. But she's representing herself. So for those of you that are new to trial watching, I really want to watch this with you guys. So because we get the unicorn of a pro se defendant, which is something to behold, but also to show you how different of a courtroom and judge and everything is compared to this case. But anyway, and we'll be able to like skip the lunch breaks and all of that. So that's my plan for after Karen Read. And then we will find a trial that is starting that we can, watch in real time. But I think because we watched Lori Vallow went to trial. Oh, they came back with a verdict on her last one, like the first day of Karen Read. So it's going to be doozy. Let's see. Oh, I lost my spot. There we go. Good point, Buffy. Well, how many crosses and directs have we seen during this trial? More than I have seen before. I'll be honest, I don't even know if I've seen a recross. But I don't know. Linda says she sat on two very interesting juries. Actually, one civil against Walmart. Oh, you should email me, Linda. I would love to hear those stories. Stephen Stern's trial is coming up, Simone. I made an executive decision when I started the show that I would not cover kid trials. They are very, very important, but I know my limits and how things affect me, and the kids they really do a number on me. I know many people be streaming it, and I will not be upset if people that want to watch that trial go watch that. Madeline Soto deserves justice, and her story heard and her image everywhere, very much so. But I've watched numerous children cases, and they mess me up every time. And that one's infuriating. That one is infuriating. Good morning, Angie. Good morning. Hope you're doing great. Here's Haley Outwood. Good morning. Good morning to you, babes. Afternoon, I mean. Maybe read the message, Llama. Let's see. Okay, yeah, there you go. Oh, that's right. We have the form now. Well, you can email me or do the form. Sometimes I know what's going on around here. Sometimes I don't. Thank you, Angie, with that assist. Good. Oh, well, also, hi. Hi. Good morning, Dope Meditations. Hope you're doing great. Wishes us all a positive week and that all your dreams come true. I wish the same for you as well. All right. Do we have a ceiling fan yet? Oh, we do have a ceiling fan. That's nice. That's all we got for that, though. What else? Oh, that light is harsh. We'll just do that for now. Too bright for all of that. Today we will have midday missing when the court is on lunch. Hopefully you will be teleported from here to midday missing. I'm going to try to figure that out, how to do that when court starts. But anyway, so we'll be doing that and then bounce you back here when court starts for the afternoon. Thursday, for our True Crime and Wine Time podcast, Terry and I will be discussing the case of Austin Harriff. He's the Florida guy who ate his neighbor's face. He killed his two neighbors and started eating the one neighbor's face. It's a wild case. It may not be what you think you know about this case, but we'll see. We'll see. Anyway, that'll be this Thursday at 8:00 Eastern. Very excited to do that. Terry and I do podcasting every Thursday night here, and we drop it on YouTube, but also on podcasts, wherever podcasts go. Good morning, Lady in Gray. Good morning. Good morning. Oh, yes, Lori Daybell will be spending the rest of her life in prison. There are no loopholes. Oh, she filed an appeal in Idaho. Good luck. Good luck. If you don't know who Lori Daybell is, this is her third separate trial. All right, she is found guilty of murdering her children, JJ and Tylee. Guilty for the murder of Tammy Daybell, Chad Daybell's wife. She just recently, on April 22nd, was found guilty of the murder of her fourth husband, Charles Vallow, and most likely is going to be found guilty of the attempted murder of Brandon Boudreaux. And then we don't have to hear from her anymore. It's been a long 5 years of dealing with that woman. That's another reason why I really want to watch it. I've invested a lot of time into this woman and her crimes and seeking justice for these people. So that's another big reason why I want to watch it. But it'll be great. Oh, thank you, Amos. Thank you. So it will teleport everybody. I love it. Haley says, I've been a witness a couple of times and have watched many court cases here in the UK. It is nothing like watching trials in America. Plus, the public do not get any disclosures here either. That's interesting. I do know that things aren't very as public as they are here in the States. I'm looking into a Canadian case for True Crime and Wine Time, and I was a little like, what? Why are things they're very they're not very transparent. And I feel like I don't understand how that's good for the public. I don't know, but you know what? I would love to talk about your country's justice system, and see how that go. You would be an amazing guest, Haley. Yes, see, Dope knows what's up. I would make it a point to watch it live when you were on the Llama stand. Same. Same. She's a Fruit Loop. Oh, you're talking about Lori Vallow. I can't understand how she got away with the death penalty. They were her children. So first they charged her with a death penalty. Now Chad got the death penalty. Lori, however, did not, because they were like, oh, she has mental issues, so we can't charge her with a death penalty. And they just went after life without parole. And what's interesting about that is, okay, so she was deemed not competent for trial for a very long time, and then she was, and they took the death penalty off. And now she's representing herself in court in Arizona for the second time. Interesting. I mean, she's not that bad. She's better than a lot of pro se defendants I've seen, for sure, but she also has had a lot of experience being in the courtroom. So, does anyone follow Annie Cushing, her latest live? Lori Daybell really split the tea. I do not know who that is, but I will surely check them out. I try to not be caught up on anything that's going on in the Lori Daybell trial. So that way, when we watch it all together, I'll be just as surprised as you are. But I do hear it's interesting. So, oh my gosh, Kay and Larry, they will be so delighted. So delighted to not have to do anything anymore. And bless them. Like, really, it's because of them wanting answers that all of this was able to come into fruition, in my opinion. Oh, so they are televising over there now. Okay, that's new. That's new and interesting. Ooh, I'd love to talk about this sometime. Okay. Lori hates the judge. Continually trying to have him removed because she finally met a man she can't manipulate. Yeah, you want to see how a regular judge works? You'll see it when we stream and watch Lori Daybell together. It'll be a good time. It'll be a good time. Oh boy, I'm going to turn my fan on. It's muggy today. That's why my hair is crazy. Like, I'm not even going to bother straighten it. I just have to do that every like 2 hours. Oh, sorry. That was probably really loud, guys. I apologize if that was. Speaking of, the lovely Amos is looking for, if people can email her, it's amy@tcwtmedia.com. She wants to know, she's putting together something really cool. She wants to put who would play them in a movie in response to the Karen Reed trial. So if you have any suggestions on who would play any of the witnesses, all of them, whoever you want to do, send those to her, because we're going to have, now that the trial's wrapping up, we have some stuff we want to, wrap the trial up with. So if you have any of those, send them her way. Your hair's lovely. Don't straighten it. Well, thank you. Thank you. Good morning, hippie girl. Good morning. I hope you're doing great. And I hope you had a relaxing weekend. I know last week was not a great one for you. So I hope this week will make up for that for sure. And so happy to see you. Excuse me. I am just like all over my mic today, just running into everything. It feels like fall today in Rhode Island. Oh, you're in Rhode Island? That's cool. It does not feel that way here right now. It's a very rainy morning. I don't know if we're supposed to get storms today. I should probably check that out. But it is humid and it's not great. Not as humid as my friends who live in the South, as they'll probably start reminding me, like, girl, it's like 96% humid here. But it's humid. So there you go. That's Amy's email. Email her for trial movie actor suggestion. Well, any celebrity, really. Any celebrity is fine. Movie actor, great, but I don't know. Any celebrity you can think of, I think she's fine with. And then we'll have something for that. Oh, Annie's the aunt of Tylee. Okay, I do subscribe to Colby Ryan, Lori Vallow's oldest and only surviving child. He has a YouTube channel as well. I think it's just Colby Ryan. And he's been talking out a lot about the trial and what it's like for him to go through all this, because, I feel horrible for him. It must be very difficult to be him. So I'll have to check Annie out. Thank you for that suggestion, Haley. Appreciate it. Okay. Well, it looks like it's 9:02. Okay, that's fair. It's only 9:02, Llama. I was going to say. Okay, well, let's see. What else do I have to tell you guys? Oh, if you guys want to see us in person, us being me and Terry True Crime, we're going to be July 19th. We're going to be in Marion, Ohio at the Blend of 7 wineries. We're going to be discussing some local cases from where I live, which is not Marion, but close, of Joey LaBute, an unsolved murder of Joey LaBute. That's one of my cases I've looked into for several years now. Unfortunately, they have no answers for what happened to him. And then we'll also be talking about the missing case of Andy Chapman. Now, tickets are on sale right now. They come in a variety of prices. I think Terry said that cheapest is like $750, but like 10 with the fees from Eventbrite or whatever, or taxes. Oh, I think it's taxes. Anyway, tickets are available to buy now, so you guys can come meet us. You'll meet us. We're gonna have a good time either way. We'd love to meet some of you in person. Now, if you can't come to Ohio, I got two options for you. One, you can send us places near you that you would like us to go do a show at, preferably wineries because it matches the theme, but we'll be open to some maybe different venues. So if you have anything in your area that you would like to see Terry and I come to a show at, please email us or send a form. I should really learn which things we have in forms now. And we'll try to book something near you guys, or you can become a member of the channel. So you click the join button. There's a tiers of what you can choose to become a member. You get to see our lives. We stream them right to you. So our in-person lives, I mean, you'll get to see them no matter what. You get to use cool emojis in chat. You get to soon use commands. You get access to member-only videos, and we're about to hook our members up in the next week or two. So you definitely want to get on being a member on our channel. So you can cancel it at any time. So it's pretty easy to sign up and do that. Or if you can't afford a membership, and that's okay. That's fine. Just liking and subscribing is an amazing thing to do for us. It's so helpful. But we do have some people in chat who are very generous and like to gift memberships. And if you go to join, you're going to see 3 little dots up in the right-hand corner. And it should say gift membership settings, and you can turn that on. And maybe you'll be gifted a gift. It is random. YouTube chooses, not the person that, gets them. But, oh, yay, you sent me an email. Okay, well, I will definitely get back to you later today, if that's all right. I am not good at multitasking while streaming. But thank you, and I look forward to talking with you, Linda. Good morning, RTC. Good morning. Hope you're doing well today. There's the instructions right there. Yes, RTC. I hope you're doing good this morning, and hopefully the smoke clears. We had a smoke alert, an air alert. Day was that Saturday or Sunday? I don't know. Because of the Canadian wildfires. So I hope you're all doing all right up there. Now that is a good fan right there. Inquisitive Room is watching on her 2 phones and a TV. I've hit like on 3. I love that dedication. Thank you, Inquisitive Room. Thank you. Good morning, Jim. Good morning. Welcome back. Hope you're doing great. Oh, see, look, the lovely Dope Meditations just gifted a membership. Thank you so much for doing that, Dope. I really appreciate your support and everything. Thank you. And to whoever became a new member, I don't have this stream pulled up, which I will do once court starts. You'd think I know how to do this, but every day is a learning experience. Over 220 fires. Oh my goodness. Oh my goodness. Good morning, Mama Llama. There's Mama Llama. That's my mama. Good morning. Hope you got all your stuff done this weekend. She'll also be with us in July. She'll be there. I'll be there. Elwoodie will be there. Terry True Crime, Amos and Company, and some others. So we're really excited about it. Oh my goodness, it's so humid. I'm going to try to not complain about it all day. I think I did tell you guys Friday that when I get hot and stuff, I get very complainy. Good morning, Savage Cashew. Good morning. Is Llama looking for questions? I mean, I'm always looking for questions, but Always. So, Mama Llama better bring some cheesecake. I told everybody about it, so we'll see. Who's on the stand today? Well, good question, RTC. Good question. Currently on the stand is still Dr. Wolf from ARCA. We are in the middle of Jackson's redirect with him. I imagine he'll be off at some point in this morning. And then they're going to have Dr. Rentschler. I don't know if it's directly after him, but I know they got Dr. Rentschler, who's Dr. Wolf's partner. He's going to testify about basically what happened to the body. He's a biomechanical engineer, so we'll probably be hearing from him today. And then, I don't remember. Oh, there we go. There's my list. So I Lapisota or Lopisada. Oh, I bet it's Lopisada is her name. Elizabeth Lopisada is the other person they plan on calling, and I don't really know who she is. So, and that's who they got. Let's see. Hippie Girl says, how much longer for trial till closing do you think? I think this is going to the jury by the end of the week. Probably Thursday. Depends on the state's rebuttal witnesses, if any. And apparently, last trial, they put a time on closing arguments. Each side was only allowed to have an hour. So we know that closing arguments aren't going to take all freaking day like they do in a lot of other trials. I've seen trials where closing arguments are sometimes timed, most of the time not. Actually, it's usually the longer cases, but even then, it's like 2 hours. An hour for closing arguments is wild to me for a case that's this long. I think that's interesting. We'll see about the cheesecake. Look at that. I'm putting it on YouTube. So you got to do it. What? Savage. This is the morning. It's just the morning. What would be the symbolic and philosophical repercussions if 6 was 9? I did say I like all questions. So that's a good one. Thank you for that. Simone says, I think that is a pharmacist who first testified. A pharmacist? Why would they have a pharmacist? I don't know. It's a good question. I have not looked who what episode it is. So, okay. This Thursday, wow. I mean, yeah, the defense said they're going to arrest tomorrow at the latest. So I wouldn't be surprised if this goes to the jury on Thursday. So by Friday, for sure, this is going to be in the jury's hands. So we'll see. But don't worry, I got other fun stuff planned for us. Okay, we're not going anywhere, even when we're in jury watch or this trial is over. We've been coming up with a good plan on how we're going to hang out every day. So I'm looking forward to it. Lady in Gray says, it depends on how much time Brennan wastes on his BS cross of witnesses and his rebuttal case. Yeah, we'll see. We'll see. Good morning, Ed B. from Boston. Good morning. Hope you're doing great today. So happy to have you here with us again. RTC says, will defense be allowed to speak during rebuttal? I mean, they're allowed to cross their witnesses, just like earlier in the case. So, but then Buffy was saying there could be like a rebuttal where the defense gets to bring more witnesses, which I've never seen, but apparently it can be a thing. I don't know. So this court is wackadoo. I don't know what's going on half the time. So, but that's trial watching. Yes, if you haven't yet, please hit that like button. Lets everyone know we're live and where the party's at, and share on social media too. If you haven't, that's super helpful. Lady in Gray, I've never seen at an hour. It's ridiculous. Odd. I think maybe I've seen an hour, maybe an hour and a half. But even that's a rarity to like limit them on closings. So I don't know. Oh, here we go. Elizabeth, well, her name's, that's not is a clinical pathology and laboratory medicine. Okay, I'm not sure if that's the same person or yes, Dr. Lapisota's first name is Elizabeth. So I'm not sure if we're talking about the same people here. A pharmacist was on the stand last week. What? Maybe. I don't know. Sometimes at the end of the day, my brain's like, I don't know what's happening. So let's see. And we're happy to have found you as well. Ooh, we got noises in the courtroom. Don't get too excited. We know what that's probably going to do. But let's see.
Was now open, you may be seated.
I heard counsel wants to see me outside, Pa.
Hi, good morning. So I just saw a transcript that was placed here on maybe reference this morning, and there's a motion to limit Dr. Rentschler that I just got that I'm not prepared for. So that we'll do later today, okay? All right. So the Commonwealth's motion to call witnesses in rebuttal. I've read everything. Ms. Little, I appreciate you getting your opposition to me. I think I had it by Saturday morning, so I appreciate it. I read all the cases on it. Does the defense want to be heard any further on this?
Yes, briefly.
Okay.
With regard to Dr. Crosby and Ms. Coon, as the court...
Speak into a microphone.
Sorry?
Speak into a microphone.
With regard to Dr. Crosby and Ms. Coon, the Commonwealth has been on notice.
Sorry, you guys. StreamYard kicked me out. Don't worry. I paused this. Super sorry about this. I don't know what it was freaking out about, but we're here. Everything is fine. Okay. Just go back just a second. Okay. All right. Sorry about that, guys. You guys can hear me, see me. We're all good. Okay. Hopefully. It's a Monday. Oh boy, is it a Monday today? I'm not sure what that was about. All right, let's get going then. Okay.
Presented at the first trial, the Commonwealth does not have a right to rebut information that they have been on notice of from the start of the case. So their decision to wait for rebuttal to call these two witnesses is improper, and we're asking the court to exclude their testimony. As it relates to Dr. Welcher, the scope of his testimony, our request is that be limited to very specific information, specifically responding to the new testing that ARCA has done. As the court knows, the Commonwealth has proposed a number of new testing ideas as well as information that is greatly outside the scope of what ARCA intends to testify to. And so we're asking that the court limit their testimony from engaging in new testing that has nothing to do with what ARCA has testified about at this trial. With regard to Dr. Welcher's testimony, the court has made very, very strong rulings that Dr. Wolf, as well as Dr. Rentschler, are not allowed to speak to the credibility of Dr. Welcher himself. And so some of the information that the Commonwealth proposes is to directly attack the testimony of Dr. Wolf and Dr. Rentschler. And under the court's rulings, we're asking that the court limit that scope as well.
And I told you I would.
Thank you.
All right.
That's
Mr. Brennan.
all, Your Honor.
Thank you. Mr. Brennan, do
It's
you
the
want to be heard?
technology people, Islam. Data
Regarding
control.
DNA evidence cannot be rebutted until it is introduced because the defense has a number of potential ideas of areas of testimony, does not compel the Commonwealth to try to anticipate or deflect attacks, especially if they're meritless. And so the issue of dogs and dog DNA does not become relevant until the defense calls a so-called dog expert. They raise the issue, it's proper grounds for rebuttal. There are three witnesses, Ms. Hartnett, UC Davis, and Dr. Crosby. If Dr. LaPosada is precluded from testifying about dog bites, we would not call Dr. Crosby as a witness. However, regardless of what Dr. LaPosada says, we would ask to call Ms. Hartnett and to call the witness from UC Davis. It is an issue that directly affects the assessment of Dr. Russell, the very expert they chose to call in the case in chief. And so we can now, from my perspective, properly rebut it. The second issue regarding Dr. Welcher, limited to the new information you will see from the testimony or have heard. Most of the testimony is new, but we understand it's limited. We don't expect Dr. Welcher to have a direct comment on the credibility of any witnesses, but he will address the tests, how he believes would be the proper procedure, and there'll be a number of issues that have been raised on written examination, but he will not in any way have a comment on the credibility of the defense experts.
All right. So the case law supports me allowing this motion. I'm allowing the Commonwealth's motion. So the motion for rebuttal witnesses is allowed. Mr. Brennan has said he will not call Dr. Crosby, depending on the testimony that comes in. So, all right, Jim, I'm just going to give you this.
Thank you.
All right, so the motion
Cool.
regarding the testimony of Dr. LaPosada.
So they will have some rebuttal witnesses.
So the Commonwealth is moving specifically to exclude, there's a motion to exclude irrelevant photographs. We'll deal with that after the main motion to exclude certain testimony. So if we start on page 7 of the report, that's where you want me to start, Mr. Brennan?
Your Honor?
Okay, page 7 of your report. I have some questions. So, Mr. Jackson, Dr. LaPosada cannot opine about the investigation of the case, the law enforcement investigation. She does that throughout her report. So she can't opine to that. But when we get to page 7, what do you say is out, Mr. Brennan? I mean, I've gone through it. I know what I think, but it's the Commonwealth's motion.
I think that her opinion about no object being present to cause a pattern injury is appropriate.
And where are you on page 7, the first paragraph?
Yes, photographs and descriptions of the site. It is the,
All right, I might have a different page 7. So my page 7, okay,
Top paragraph. Your Honor.
okay, yep.
Dr. LaPosada proposed opinion that photographs and description of the site where Mr. O'Keefe's body was found show no object capable of producing a pattern injury, I think is appropriate. His body was found on flat, grassy ground, probably frozen and covered with a minimal amount of snow. I agree is appropriate. It is the next paragraph where it begins in the middle of the sentence. It is logical to conclude that Mr. O'Keefe was injured elsewhere and his body was moved to the front lawn. There is no basis in fact for that. It's an improper opinion.
Yeah.
We left the argument.
So I told you that on Friday, Mr. Jackson.
We're not seeking that.
Great, okay, so that's out. And Mr. Jackson, again, the medical examiner erred in her diagnosis of hypothermia. Again, that's the improper critiquing of the expert. She can say that it wasn't hypothermia, obviously. Okay, so same with the first sentence of the next paragraph, the Wisniewski spots were misidentified.
We're not seeking that.
Great, all right, so we can probably do this much quicker then. All right.
Probably could have done this a long time ago.
All right, so page 8 is fine. So now we go to page 10. So this is the dog bites. So if you want to pick it up at, what does the Commonwealth say about this?
At this point, there's no basis provided that she has the training expertise, methodology to provide an opinion regarding the dog.
What's the offer of proof on this, Mr. Jackson?
It will be more extensive when I establish the foundation. Testimony, basically, she's not only done autopsies involving dog bites, the wound pattern recognition related to the source of those dog bites. She's also taught classes on wound pattern recognition, source of coming up with diagnoses concerning the source of specific pattern of wounds. She has a methodology that she uses. Medical school classes, I didn't mention, the courses.
What does she teach? Is this in her CV? Because I didn't see it.
It will be in her foundation that I will lay from the jury.
All right.
I won't see any opinion unless and until the foundation is properly laid, but she has extensive experience, not only with specifically with autopsies that she's conducted herself, but supervising autopsies of others that deal with pattern recognition, the methodology involved with pattern recognition.
How about dog bites?
Dog bites specifically, 5 autopsies. I believe she will indicate that she's done 5 autopsies as they relate to dog bites.
Okay.
A medical school class specifically on the issue of wound pattern recognition, which that class includes dog bite recognition.
All right, so we'll need a short voir dire of her on this before she testifies.
Because the court doesn't believe that I can lay the foundation in front of the jury and forego a voir dire. I won't ask any ultimate question until we go to sidebar, but I think we can short circuit that.
She's very specific about the dog bites here. So if she's seen 5 autopsies with dog bites, I'm not inclined to give it to you. Okay? Seen only 5 in her 40 years or whatever.
It's not that she's only seen 5, she's performed 5 autopsies.
Okay, so that's why we need a voir dire. So we need a very short voir dire.
She's also been qualified on the issue of dog bite wound pattern recognition in federal court as well.
Okay.
So she has a plethora of foundations.
Has that been provided to the Commonwealth in advance of today?
I don't know.
None of it has. So here's the difficulty, whether it's a voir dire or it's in front of the jury, I have absolutely no ability to research and cross-examine her on dog bites. She can say she had 1 case or 50 cases, that she testified in state or federal court, or she took a class. I can't verify it, I can't contradict it. I have no ability to prepare for this witness about her basis, methodology, and experience in dog bites. What I have is her showing a couple pictures that she pulled from her book, and then she has some Google or Shutterstock research in her report. And so the idea that she has a history or basis is going to be uncontested, because there's nothing I can do to contest it, and that's not appropriate. I should be able to research, get transcripts, vet, and be able to approach the witness on whether or not she actually has the reliability of education and experience. I can't do that if we call her an access or audit.
But that's where, if we want to compare apples to apples, Dr. Wolf, Isaac Wolf, was allowed to specifically testify to the wound pattern, his interpretation of wound pattern recognition back then. That was nowhere in his report. That was objected to by the defense. Mr. Alessi, went to sidebar, strenuously objected, said this is nowhere in the report. We didn't have any notice of this, and the court said, overruled, he's allowed to testify to the pattern of recognition. At least in his mind, you can cross-examine him on it. There is no requirement that the Commonwealth have every single case that Dr. Llama has ever dealt with, dealing with.
No, we had an expert on dog bites who I allowed to testify as to dog bites based on, we had a whole, as you know, it was Mr. Leslie, I think 3 days with Dr. Russell on the voir dire. This is new to me. I'm going to have a short voir dire on to what she can testify to.
I have no problem with voir dire, I just wanted to short circuit it. But I have
So,
to entertain that.
all right, so let's go on to page 17.
Commonwealth has an objection to the third line, Mr. O'Keefe's pattern injuries, mine's right arm, do not correspond to injuries that could have been produced by a regular fractured plastic pieces impacting his arm. She is not qualified as a reconstructionist or biomechanical engineer. She's tried another course and been rejected. She does not have the experience, the background, or the ability to do that.
What do you say, Mr. Jackson?
Your Honor, I believe she does, as a medical examiner, have the experience, and it's the qualification, it's the specific job of and the qualification of a medical examiner to opine on pattern injuries. If the foundation is laid, especially as it relates to motor vehicle accidents, and now we're not talking about dog bites, which are a more defined subset of her overall experience. Now we're talking about motor vehicle incidents and accidents that she is specifically seeing thousands of.
Okay.
Multiple thousands.
So,
If she does have the qualification to say, if the proper foundation is laid, that the wound pattern that I see on Mr. O'Keefe's arm is inconsistent with anything that I've seen in terms of a motor vehicle accident.
so let's just find out how many motor vehicle accident autopsies she's done during that voir dire. What I have a question about is tail lights are typically made of durable polycarbonate or acrylic plastic. I would keep that out. I'd be inclined to allow in the injuries on his right arm do not correspond to injuries that could have been produced by plastic pieces impacting his arm. But let's hear about that.
I wouldn't ask about polycarbonate. I have no intention of asking about that.
And also the last sentence, I think it's okay, and we'll see with voir dire. Neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes, assuming she has experience with autopsies of motor vehicle accidents. But I would keep out the part as would be expected from pieces of shattered tail light. Was there more on that?
I object to that because this is now yet another witness that's coming in under the guise of some type of specialty, but really for accident reconstruction.
All right, so let's see what she says on voir dire regarding her experience with accident victims. I think she gets more into the accident reconstruction on the next page that I don't think is proper.
Which I am not seeking to choose.
All right, so that whole first paragraph on the next page, you're not seeking to introduce? Yeah.
At least the first, we're starting with the first sentence. Yes, we would be seeking to introduce that. Pedestrian injuries produced by contact with motor vehicle include a component tissue crushing force as the car profile protrusions connect. That's basic. I believe that she does have the qualifications to opine about that. That's pretty standard, and that should be admitted.
She has absolutely no experience in accident reconstruction or the injuries. She is not a biomechanical engineer. They have one, and he's going to testify to it.
Yeah, I have that as out, Mr. Jackson.
The reason that I believe that it's appropriate is because you don't have to be a biomechanical engineer to understand when you see, for instance, a known pedestrian accident, what are the results, especially if you've seen hundreds or maybe even thousands, what are the results that you typically see in the wound patterns, for instance, crushing forces, broken bones, fractured bones, crushed soft tissue, things of that nature, internal bleeding. That's the province of medical exam.
Okay.
That's exactly what they are trained to identify and to opine on.
Okay,
I wouldn't get into things like, for instance, what she doesn't have the experience to do is say, when a car is involved in a rollover collision, these are the mechanical forces that are exerted on the body during a rollover, and the G forces that the body is subject to in rollover, things of that nature. When a car is impacted head-on by another car, there are a number of G forces that are put upon the body, etc. Those are biomechanical issues, have nothing to do with her expertise, and I wouldn't be seeking anything like that. But once the body is removed from the car, and then it's on the autopsy table, that's where her expertise begins to fly.
okay.
She can talk about, and I believe she has the experience and the qualifications to talk about what the body suffers at the hands of a vehicle, pedestrian incident, or accident.
Okay, so the first two sentences are out. The third sentence, she can testify that Mr. O'Keefe had no bruising on his arms or torso. And she can testify, and she cannot say that would have resulted from the impact with the SUV rear profile. She can say Mr. O'Keefe did not have bruises on his legs. She cannot say from bumper contact, but she can say as shown by dissection of leg tissue and muscle at autopsy. And she can't testify to anything else in that paragraph.
Your Honor, is the court ruling that she cannot say anything
I
about
don't know.
the human body contacting a motor vehicle? That sounds like what the court's saying.
No.
I think that's too narrow a ruling.
It is. You can put this in, what I said you could put in, can come in, and the rest cannot. We could,
And just for point of clarification, if I ask her, would you expect, I'm just gonna make it a hypothetical, would you expect if his legs were contacted by a moving vehicle, would you expect to see bruise or contusion?
what do you say about that?
I object, one, it's leading.
Well, I'm
Secondly,
not asking the question.
secondly, this is asking to have Dr. Lavasada do accident reconstruction. She's not assessing a wound. I'd ask you to consider the case of Commonwealth versus Tompkins.
Agreed.
I think we provided at 105 Mass Ave 1124, 2025 case. And a similar attempt was made to try to use Dr. Lavasada as a biomechanical accident reconstructionist. Trial judge did not credit her proffer and found that she failed to meet the requisite criteria for Dower Flanagan. And so recently it's been found by at least another court that she is not competent to do this because she's a medical examiner, does not allow her to come in and start endorsing or vouching for the armed witnesses. They already have witnesses to do that. And so not only on page 18, going back to page 17, about the pattern injuries don't correspond to injuries to a light, she would only know that if she had the training
Where,
experience.
I'm sorry, where,
You said on page 17, you would allow Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by a regular fractured plastic piece impacting his arm. That's not her role as a medical examiner. That is the role of a reconstruction or a biomechanical engineer. And she clearly is not competent, at least as cited by the appeals court, to have that type of opinion. And so there's one thing to assess wounds, there's another to try to correlate and draw a distinction between wounds in a car collision. It is essentially giving an opinion to the jury, he didn't get hit by a car. That is the core fundamental theory of the defense. This is simply trying to bootstrap another witness to give that opinion. That's improper.
all right, sure.
Mr. Brennan's going to cite the Tompkins case. He needs to cite the Tompkins case. That dealt with a situation in which a witness was called and she was asked by the lawyers, specifically in that case, the people that called her, the lawyers that called her, to opine about blood-stain pattern recognition, blood spatter evidence on the driver's seat versus the passenger seat, and what her opinion was about who actually was driving the vehicle. It was a rollover collision in which people were ejected from the car. She was then asked to opine about bloodstain patterns in the driver's seat and whether that was more or less consistent with the blood, the originator of blood, one particular individual, was he more likely in the driver's seat or the passenger seat at the time of the bleeding, and was it before or after the rollover? Very, very different set of facts. And of course, that is a biomechanical engineer's province. And the court was correct in saying, I'm not going to credit her testimony on that issue, but that's what she was asked. She opined on it. The court said, I'm not going to credit her testimony.
All right, so
This type of analysis and wound pattern recognition, which is what she's being asked to do.
So let's see with her voir dire this morning.
Okay.
She actually was allowed to testify about blood spatter. It is the reconstruction testimony that she was not allowed to testify.
I read the Superior Court judge's decision. I have not read the appeals court rescript, so I need to do that. I'd like to get going, but there are photographs of inside the garage. You intend to put this in through Dr. Lopesada?
No, Dr.
Through whom?
Yeah, can I do this? With regard to these photos, well, ultimately, the Lopesada will be shown them, correct? That they'll be introduced through our investigator who took the photos. We intend to call that investigator after Dr. Wolf testifies.
And what will that investigator say? These are photographs.
So he will testify to two subject areas. One would be took measurements from the street to the various entrances to 34 Fairview. We just have to tell testify about what those measurements were. And then he took several photographs. We have pared them down to, I think, 3 or 4, just of one establishing shot showing the garage from the street, and then a couple of photos showing the side entrance to the garage, the pedestrian entrance to the garage, and also showing the interior of the garage, including a step and a
For what purpose? How are they relevant?
I'm sorry.
How are they relevant?
So the defense is presenting a Bowden defense in this case. We are alleging that the police did not do a thorough investigation. They did not really investigate anyone other than Karen Reed. The Commonwealth's own evidence, including the testimony of Ian Griffin, is consistent with John O'Keefe after what they claim to be the trigger event in Dr. Welch's initial report. John O'Keefe walking in a westerly direction, which would be from Fairview Road to the house, taking approximately 36 steps over a distance of 25.4 meters, which is approximately 84 feet. That is consistent with him entering the house. It's consistent with him entering the garage. The police did not take photos of the garage. They didn't investigate, is there a hard surface in the garage? Is there a ridge-like surface in the garage? And these are photos are introduced on that code mission to say that there was evidence in the house. If the police only went in there, they would have seen that. And that may have sent them in a different direction. So it's relevant for that purpose.
Do you want to weigh in on this?
These are not only relevant and not material, it's misleading. They are not seeking to have measurements from the flagpole to the door. They're trying to seek measurements from the driveway to the door. There is no evidence whatsoever John O'Keefe was ever on, near, or anywhere by the driveway. The evidence is that he was at the flagpole. While the data showed there was a turn westward, it didn't show movement westward. It did not. There was a measurement from the flagpole to the garage door. That is something that I think would be appropriate. From the driveway, totally irrelevant. There's no evidence, no witness, no substantive evidence in this case that John O'Keefe went in the house, went near the house, was dropped off. They're relying simply on the fact that there were 37 steps. They have no idea what direction or where. What they want to do to argue this is to show inside the garage and then posit the theory that somehow John O'Keefe was killed in the garage. It was colder than it was in the regular house. That would account for the temperature on the battery. They have no evidence to support that. You can't use Bowden as a panacea. You can't just say Bowden, they should have done what we want them to do. It is what is reasonable. The police went into the house. They spoke to the occupants of the house. There was no evidence that Mr. O'Keefe went into the garage. You might as well take a photograph of anybody else's garage in America and put it up in front of the jury. So this is going to create a mistaken, baseless argument that this evidence somehow shows that Mr. O'Keefe was A, in the garage, and B, he was injured in the garage. That's why they want to show it to Dr. Laposada. Couldn't some of these angles have caused the injury? Total speculation, no relevance at all, and it is just prone for an opportunity to mislead this jury. This should not come in.
If I may respond in 4 ways. First of all, Mr. Brennan just informed this court that there was no evidence of movement of the phone. I'd like to quote his own witness. At 12:25:30, the device's bearing shifts to a westerly direction, as location records also show the device moving west from the roadside toward the house. So that was false. Secondly, with regard to, we should be measuring from the flagpole, our theory is not that he entered the house from the area of the flagpole. Our theory is that he was placed at that flagpole. And as Mr. Brennan correctly points out, there's no evidence that they introduced as to where he was on the road prior to walking into the house in that westerly direction. Our theory is as good as his. He cannot prove anything to contradict our theory. The third thing is that Ryan Nagel and Heather Maxson saw Karen Reed in her vehicle alone. The passenger seat was illuminated and empty. John O'Keefe was nowhere in the area of that vehicle. He was not in that vehicle. There's only one other place that he could be, and that is in the house. So finally, the fourth point, Your Honor, this court has continually always done, as the court should, a 403 analysis. The probative value we have established through their own witnesses. They called all of these witnesses and they established the foundation for the admission of these photos. There was no unfair prejudice. I would argue that anytime there's exculpatory evidence or a case that advances the defense theory, that's by definition going to prejudice the Commonwealth's case. This is not unfair prejudice. He is allowed, Mr. Brennan is allowed to cross-examine this witness and to make whatever arguments he wants to make about the likelihood of the garage being involved or not. But he does not and should not get the benefit of the fact that his investigation, the police investigation, didn't do what we just did. And this evidence should be admitted.
The argument is purely rhetorical. There's not one fact he offers. The witnesses that saw the car saw it in front of them. Nobody ever got out. A light on doesn't mean that he wasn't near the car because they didn't see him in the front seat. So there is no evidence that Mr. O'Keefe went anywhere near the house, on the breezeway, in the door. It is speculative, it is baseless. They want to take that baseless argument and then bootstrap it to Dr. Lapasada to further speculate that something in the garage that could have caused the injury. That is not Bowden. That is not a due process right. That's not 403. It's empty. It's no factual predicate whatsoever.
Okay, so,
The only other thing, just to put a cap on this, the location data circles, again, Mr. Brennan's own evidence, he introduced it, puts John O'Keefe in the house.
all right, so I'm going to allow you to do the measurements. These photos will mark for identification. The photos are not admissible. So, all right, Chrissy, can you just mark those, please? All right, let's bring the jury over. We will do, Mr. Jackson, how long will you be with Dr. Wolf?
Probably 20 minutes.
All right, and depending
Yes.
on that. All right, so during the morning recess, we'll do the voir dire of Dr. Lapasada. All right, bring one over, please.
Okay, crazy that we are doing this right now. Why is she limiting? Oh, oh boy, you guys, I can't wait for this trial to be over. This is so annoying. So basically what they're trying to do is limit Dr. Lapasada, who is a medical examiner, from being able to testify that the wounds on John's arms are dog bites and not from a car. The defense says she's done 5 autopsies of people who were attacked by dogs. Bev says, that's not very many. I don't think that's enough. Like, very okay. I don't, they're basically talking about how she wasn't qualified to talk about these things, which is very confusing because, like, that's literally her job, kind of, but okay. So during the break, they're going to voir dire her. We're going to finish up Dr. Wolf. Then they're going to voir dire Dr. Lapasada. And then they're going to call their private investigator who's going to submit some photos. And then it sounds like Dr. Lapasada is going to be after that. I don't think it'll be Dr. Welcher today. So that is interesting. I'm kind of over Brennan being like, yeah, but Your Honor, we didn't know about that. I don't have anything to combat her CV. This is all brand new information. Like, what? What do you mean this is brand new information, sir? Oh my gosh. Gula's mom says, in my opinion, Hank knows that Yeti is right and has to play the part of poor us, the CW. It's very annoying. She is allowing the defense. Yes. That's exactly. See, then we go back to Ian Whippen, right? That guy who said that John went 36 steps or 34 steps, 30 something steps, which equals 86 feet, which puts him in the house. So they seem to like not want to focus on that because it doesn't make their case hold up. So, right? And she's all like, well, I don't know. I don't know if Dr. Lapsota is qualified. She's only seen 5. What about Dr. or not, sorry, whoa. What about Mr. Burgess, whose CV was a load of crap? What about that guy? It's crazy. They have nothing. It's very annoying. Yes, she should have taken 6. How dare she? Oh yeah, over her, right? And they should call Rescue Randy. Oh, the hero of the story, Rescue Randy. We all love him. Exactly, Shonda. The CW has constantly backed the Commonwealth bus over their own witnesses. Several times they've done this. And it's crazy. It's crazy to me. I can't wait to watch a regular trial with you guys. Oh, hello, Kathy. Hello, good morning, babe. Hope you're doing great. Hope you're doing great. Well, I don't see why this couldn't have been discussed on, all those days off or, anything like that. By the way, did you guys hear the court reporter? Because I did. She sounded like the voice in Charlie Brown, but you could hear it's like, it's definitely coming from her. It's like, oh, that's interesting. Never be qualified by Bev since you got your bachelor's the same time as you got your diploma. Oh, wow, that's interesting. That's interesting. Lady Grace says the defense has done a great job turning the Commonwealth witnesses and testimony into defense witnesses and testimony. I agree. And then Brandon is like, but I don't want anybody else to testify. Now, he did say he was planning on calling some rebuttal witnesses, so may not go to the jury by Thursday. I don't remember exactly who he said he was going to call. I feel like there's a Dr. Crosby or Cosby or something. If they call Dr. Lasso, I forgot what her name is already. Lapsota. So it sounds like they have like possibly 3 rebuttal witnesses. So we'll see. But we're going to have Dr. Wolf back on the stand, which I know chat will be very happy about. If you guys haven't yet, like this video, subscribe, hit the notification bell, do all those things. Share on some social media. It's all free and much appreciated. All right, I need to put my...
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Not really. Inquisitive, not really. Just in time for Dr. Wolf.
Okay. All right. Good morning again, counsel. Good morning, jurors. So we appreciate your patience. We were in here trying to streamline things, so we got a lot of work done this morning. So thank you. I do have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here on Friday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Friday? Everyone said no or should. Thank you. We have Dr. Wolf, please.
Sure, I'll remind you, you're still under oath.
All right, good morning.
Good morning.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Dr. Wolf, thank you for joining us again this morning. I'd like to draw your attention to a picture. I'm going to. May I approach you?
Yes.
I'm going to show you. Do you remember seeing that photograph?
Yes,
You were shown this photograph last week, is that right?
correct,
By Mr. Brennan, correct?
correct.
Do you recognize the photo as the same photo that you were shown last week?
Yes,
Under questioning by Mr. Brennan?
yes.
And what does that appear to be a photo of, just generally?
It appears to be a photo from the test dummy from the 29 mile per hour impact test.
Does that appear to be a true and accurate photograph of the condition of the dummy following that 29 mile an hour crash test?
Yes,
With the court's permission, I'd like to enter this as next in order, please. If you could hand that to the lower corner.
Exhibit 218.
Permission to present that, Your Honor?
Yes.
Is this the photograph?
yes.
Dr. Worth, first of all, what caused the damage? Well, let's start with the most basics. Which arm is this, left or right?
This is the left arm.
What position was, you called this dummy Rescue Randy, is that right?
Correct,
What
yes.
position generally was Rescue Randy in upon impact during this test?
He was oriented such that the right side of his body and his right arm would be contacted by the vehicle.
What caused the defects in the and the damage to the sweatshirt as we see it here?
That was due to the interaction from the Rescue Randy sliding on the pavement surface to his position of final rest.
Is that sometimes called road rash?
Yes,
Did you see any road rash in any other place on Rescue Randy in this photograph?
doesn't appear so in this photograph, no.
Can we highlight the face?
Maybe.
What about there?
Sorry, I thought you were talking specific to the clothing. Yes, the as I mentioned on Friday, there were signs of road rash to the body of the dummy itself on the face and on the torso and arms.
Can we zoom in on the sleeve a little bit? Do you see any staining on the sleeve as well as the defects, the holes and the tears?
Yes.
What is that staining from?
Again, just from that sliding contact with the pavement. So it's just likely debris and kind of a film from the pavement surface being deposited onto the material.
With regard to John O'Keefe's sweatshirt that you reviewed photographs of, did you see any other defects other than the right arm and the fact that it was cut off of him medically?
No.
Any other indication or any indication whatsoever of anything that you see consistent with road rash?
No.
Okay, let's go back to full frame. The second image I'd like you to take a look at. If we can have the lights for just a second. Do you recognize what's depicted in that photograph?
Yes.
How do you recognize it?
It is the backside of the test dummy from the 29 mile per hour full-on impact test.
Which arm is featured in that photograph?
That would be the right arm.
Move that into evidence as next in order, Your Honor, with the court's permission.
Exhibit 219.
Permission to display?
Yes.
That's funny.
Does that
R2
appear to be the right arm of Rescue Randy as he's face down?
Yes.
Is that following the impact?
Yes.
Do you see any, were you shown this photograph by Mr. Brennan on cross-examination?
No, I was not.
Can we highlight the right sleeve just a little bit, please? You see that defect in the sleeve?
Yes.
Do you also see some artifacts above that defect, above and to the left?
Yes.
Can you tell what those are?
They appear to be fragments from the back window of the test vehicle when it shattered.
Does there appear to be any additional, let's go back to the full frame. Does there appear to be any additional defects on that particular sleeve?
There appears to be some material transfer, likely from the pavement, and also some road rash.
Does that appear to be transfer from the pavement?
I think that might be a shard of glass from the back window.
What was the condition of the back window after this test?
It was completely shattered.
The defect that we're looking at, that large gash, was that from road rash sliding on the pavement?
Yes.
If we can go back to the full frame, please. I'd like to show you an additional photograph. Do you recognize what's depicted in that photograph?
Yes.
What is it?
It is the front side of the test dummy from the 29 mile per hour full-on impact test.
Does that appear to be a true and accurate depiction of the condition of Rescue Randy in that sweatshirt after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph, Your Honor, is next in order.
Exhibit 220.
Permission to display?
Yes.
Can you describe what we're looking at in this photograph?
This is mainly showing the upper body of the test dummy from the 29 mile an hour impact test, showing the road rash to the front side of the body.
Were you shown this photograph on cross-examination?
No.
What caused the holes in the bodice of the shirt? In other words, the part that covers the chest and the torso.
After the impact, the dummy was projected and sliding on the pavement surface. So again, this is consistent with the front side of the body making sliding contact with the pavement, creating those abrasions and holes. And again, that asphalt material transfer that you see on the front.
Can you go up back to the full frame, please? Do you see additional road rash? Take a look at his right arm. You see additional road rash on Rescue Randy?
Yes.
On both the fabric and the arm itself?
Correct.
Go back to full frame. And can you see his face as well in this photograph?
Yes.
Are those the chin and nose defects that you saw?
Yes.
Are the defects in the shirt that you see here consistent with the condition of the shirt of John O'Keefe as you saw it in the photographs?
It is inconsistent.
May I approach, Your Honor?
Yes.
Another photo that I'd like to show you. Do you recognize what's depicted in that photograph?
Yes.
What is that? We can take this down.
It is the rest position of the test dummy after the 29 mile per hour impact test.
Were you shown this on Friday?
No.
Is that a true and accurate depiction of the condition of Rescue Randy just from a different angle after that 29-mile-an-hour impact?
Yes.
Move for the admission of that photograph.
Okay. Exhibit 221.
Permission to display that photograph, Your Honor?
Yes.
Is this an overview of the entire body of Rescue Randy after that impact?
Yes.
Take a look at his torso, the exposed portion of his torso. Do you see road rash on his exposed torso? Do
Yes.
you also see that the road rash that you earlier described on the bodice of the shirt, the front of the shirt?
Yes.
And what about, let's go back to the full frame. Is there also road rash on his jeans?
Yes.
We could go back to full frame. Have you ever heard a phrase, knocked out of your shoes?
Yes.
Where are the dummy shoes?
They are still on his feet.
And this is at an impact of 29 miles per hour, correct?
What's the form of the question?
Sure. What was tell us one more time, what was the speed of this impact?
This was a full-on 29-mile-per-hour impact.
We can take that down.
Yes.
Take a look at that photograph and tell me if you recognize what's depicted in it.
Yes.
What is that?
It is the back of the test Lexus after the 29-mile-per-hour impact test.
Is that a true and accurate depiction of the condition of that Lexus following that 29-mile-an-hour impact?
Yes, and I should be more specific. It's post the 29-mile-per-hour impact with the test dummy, not just the arm.
Understood. Thank you. The collision that caused the damage to Rescue Randy that we've just been looking at.
Correct, yes.
Okay. Move for the admission of that photograph, Your Honor.
Okay. Exhibit 222.
Permission to display that?
Yes.
Is this the rear of the photograph that we were just talking about?
Yes.
And this is the condition of the vehicle after that rearward impact with Rescue Randy, correct?
Correct.
Did the subject vehicle photographs that you looked at, were those consistent or inconsistent with this photograph?
Those photographs were inconsistent compared to the test.
Was there anything consistent about the shirt that you were shown on Friday, the left sleeve that you were shown on Friday with John O'Keefe's actual sweatshirt?
Was any of that consistent with?
Correct. Was that consistent or inconsistent, now that you've seen all the photographs, with the condition of the shirt that John O'Keefe was wearing on January 29th?
The test clothing was inconsistent compared to that of Mr. John O'Keefe's.
Thank you. You were asked on cross-examination several times about the weight of the Hybrid 3 arm. Do you recall that series of questions?
Yes.
You were asked how much lighter the Hybrid 3 arm was than the static estimate arm, correct?
Correct.
I want to make sure we're clear about this. The Hybrid 3 arm is the physical arm that you attached to the ATD and did testing with, correct?
Correct.
The statistical estimate arm is something in the ether, right? It doesn't exist.
Sustained.
How would you describe a statistical estimate arm?
It's probably from taking a sample of the population and getting an average and a high and a low.
Okay. Is that a physical arm? You touch and feel?
No.
Okay. Do you have any information based on everything that you've reviewed at all actual weight of John O'Keefe's right arm?
Nothing in terms of a weighed measurement of the arm. No.
Okay. What was the percentage that Mr. Brennan gave you in terms of how much lighter the hybrid 3 arm was than the statistical estimate arm that he gave you?
From what I recall, I think the percentage was 26%.
Did you calculate that yourself, or did you take Mr. Brennan's word for it?
I believe I took his word for it.
Do you recall what the weight of the hybrid 3 arm was exactly?
9.38 pounds.
What is the difference, if you can calculate, what is the difference between what was the statistical estimate arm, the number that Mr. Brennan gave you?
I think I heard him say 11.8, but I also think he said at one point 11.6. So I'm not sure of the final number he landed on.
Does
Sustained. Ask the question. Stop striking the end.
Does 11.86 sound right?
Yes,
Okay. Let's use 11.86. Do you have a calculator with you?
I do.
With the court's permission, could Dr. Wolf use a calculator if he needs to?
Yes.
Thank you. What's the difference between 11.86 and 9.38? Just in raw numbers?
You're looking at just the difference between those two?
Subtract
Oh, okay.
9.38.
Yep. 2.48.
Does that mean there's a 2.48 pound differential between the statistical estimate arm, the heavier arm, and the 9.38 arm from the hybrid 3?
Yes, that's the difference in pounds.
All right. How would you calculate how much lighter? What's the proper way to calculate how much lighter in terms of percentage the 9.38 arm is?
You would want to do a percent difference calculation.
Divide 2.48 by 11.86?
Sustained. Watch the form, Mr. Jackson.
How would you tell the jurors how you would calculate that percentage difference?
You would subtract the 11.86 minus the 9.38, and then you would divide by the sum of those two and divide by 2, the average of them.
Can you do that calculation?
Yes. Okay.
And what's the number?
23%.
Not 26%?
Sustained.
Is 23% smaller or larger than 26%?
Sustained. Let's move on from that, Mr. Jackson.
What is the number that you get if you were to divide 2.48 by 11.86?
0.21.
In percentages.
21%.
Thank you. Was the hybrid 3 arm 21% lighter by that calculation than the 11.86 estimate arm?
Yes.
On cross-examination, Mr. Brennan asked you several questions related to kinetic energy formula, correct?
Correct.
You referenced that. Did you reference that formula in some of your answers?
Yes.
May I approach?
Yes.
I will be so happy when we have a trial that doesn't involve so much math this early in the morning. I mean, ooh. At least they can do it. That's why we're not experts, I guess. My math skills aren't up to par. I think they did a great job showing, the back of the test vehicle, the amount of road rash that one would expect to find on a body. And what do you think? What do you think Brennan's like counter that to that is going to be illegal? Yeah, it's not the asphalt we think you landed on. It was the ground. You mean the hard ground that you said cracked the back of his head? I would still feel that there would be those kind of holes all over his clothing, more so. Monday math. Yeah, I'm not a fan. Not a fan of Monday math. By the way, it does appear that we are supposed to be getting. Oh, we're just on an air quality alert right now. For a couple more hours, but we're supposed to get storms today too. So hopefully that doesn't cause problems for our stream. I've only lost power one time, so we'll see. We'll see what happens, but I don't know what time they're supposed to be here yet. You read that as something else. That's funny. Lady in Gray says he still have tears in his clothes from hard ground, but what will he say about the back of the test car? Agreed. He'll probably be like, yeah, but it was only 24 miles an hour, not 29. Hi, Dave. Good morning. Hope you're doing well and had a wonderful weekend. Welcome back. Welcome back. Waiting for Hank to say the frozen sawgrass caused the arm injuries. Maybe. We don't know. We'll see. I'll certainly be doing some stretching, I'm sure.
May I inquire?
Yes.
You're looking at something that's been identified, a document that's been identified as 3 X's, XXX. Do you recognize that? Oh, you're not looking at it. Sorry.
Not yet.
You see it now?
Yes.
Do you recognize what that is?
It is the formula for kinetic energy.
With that, Your Honor, may we display the formula? We don't have to cut the lights. I think it'll be very obvious.
Yes.
We're going to do it anyway.
Can we bring the lights back up and see if that's visible? Can you still see that, Dr. Wolf?
Yes.
Your Honor, is that okay?
Yes.
Great. You said this is the formula for kinetic energy, correct?
Correct.
You were asked a series of questions about whether the weight differential in the hybrid 3-arm would make a significant or material difference in your testing as it pertains to the velocity of the vehicle that you were testing. You remember those questions?
So watch the phone. Ask a different question.
Just foundationally, were you asked about weight differential of the hybrid 3-arm?
Yes.
Were you also asked about whether it would make a material difference to the testing if you didn't adjust for the velocity?
Sustained.
What were you asked in terms of, what was the question that was posed to you about the weight of the hybrid 3-arm versus the velocity of the testing?
That there would somehow be an influence on, I think, wanting to make a reduction to the velocity of the vehicle.
Does that make mathematical sense to you?
Sustained is to that point.
Would that have a material difference? With the weight of the arm at 2.48 pounds, would that have a material difference in the testing that you undertook?
No.
Why is that?
Well, to start, that's one of the reasons why we went above and beyond the 24 miles per hour to impart significantly more kinetic energy to the arm. So if you look at that equation, it's a quadratic equation because you're squaring the velocity. So if you double the velocity, you quadruple the amount of kinetic energy. So you get a significant increase in small changes in speed because of that speed differential.
Did you do a test with just the hybrid arm contacting the taillight at 24 miles per hour?
Yes.
Did you also do a test with that hybrid 3-arm contacting the vehicle at 29 miles per hour?
Yes.
I'd like to talk about those two tests. Okay? Can you explain to the jurors what they're looking at? I want to start with going from left to right. What does the E sub K mean in that formula?
So that stands for kinetic energy, which is the amount of energy that an object has when it's in motion and has a velocity to it.
What is the 1/2 on the other side of the equal sign?
Just a constant.
And what does the M, as in Mary, stand for?
So that would be the mass, in this case, the mass of the arm.
And what's the V, as in Victor?
That would be the velocity of the arm as it's accelerated.
Why is there an exponent at the top of the V?
Very inquisitive.
Because you're squaring that. So you're basically multiplying the velocity times itself. So it'd be velocity times velocity.
Is this a formula that's traditionally used in accident reconstruction?
Yes, it's very common.
Is it sort of one of the foundational formulas? When did you learn this formula?
Probably back in high school physics.
I'm going to ask you, if you wouldn't mind, to walk the jurors through a calculation dealing with the 24-mile-an-hour test using the 11.86 pound statistical arm as an assumption of the weight of the arm.
Okay.
You
Your Honor,
understand?
may I have a pen and paper to write?
May I approach you, Your Honor?
Yes.
I have a pad here too, if whatever's easiest.
Okay, whatever's easiest. If you assume the mass of 11.86, that's the statistical arm weight, and you assume the V for velocity is 24 in miles per hour. I don't care about the units, doctor. Just assume 11.86 and 24. Can you calculate this quadratic equation?
Yes.
What do you get? I want to do it step by step. What's the result of squaring 24?
So you're not concerned about the units?
I do not want to talk about units.
Just, okay.
If you mention the word joules, my head will explode.
That's, I didn't know if you wanted, Newton meters, foot pounds. Okay.
Stop it.
So
Immediately.
just 24 squared
Correct.
is 576.
Do you always, in this calculation, do you always use the exponent first? Do you always do the square first?
Sustain.
What's the first thing that you do in solving for this equation?
You would want to square the velocity, but it's ultimately all going to be multiplied. But yes, you would square the velocity, multiply by itself.
What's the next step after you get 576?
Again, assuming we're not concerned about units, you would multiply by the 11.86.
Can you do that for me and tell me the answer?
How many decimal places do you want? Just nearest whole number?
2.
Okay. 6,831.36.
What's the next step once you get that number?
You would multiply by 1/2 or 0.5.
Can you do that for us, please?
That'd be 3,415.68.
What does that represent in terms of the energy into the taillight? I realize that we're not dealing with the proper units, but does that represent anything as it relates to the energy that's imparted on the taillight?
That would be the energy to the arm.
Okay.
That's being transferred.
Understood. 3,415.68. Is that right?
Correct.
And that was at what mile per hour?
24.
let's move to a different equation.
Okay.
Now I'd like you to presume different numbers.
I don't know what the question is.
Can you do the same calculation using the 9.38 pound arm that you actually used in your testing for the mass?
Yes.
And can you use the velocity of the actual test you did of 29 miles per hour?
Okay. And same thing, not worried about units?
Correct.
Okay.
What's the first thing you do in solving that equation?
So if you square the 29 miles per hour, you will get 841.
What's the next thing you do?
You multiply by 9.38,
What's the number?
7,888.58.
And what's the next thing you do in the equation?
You multiply by 1/2 or 0.5,
And what's that final number?
3,944.29.
That would be the
Triple X
the
exhibit.
number or the amount of energy imparted on the arm at 29. Is that right? 29 miles per hour?
So ask it differently.
Sure. What is that 3,944.29 number? What does that mean in terms of the kinetic energy?
That would be the kinetic energy that the arm has if it were moving at 29 miles per hour and weighed 9.38 pounds.
One final calculation. What is the percentage difference between 39, 44, 29 and the other test that we just did, or the other calculation, 34, 15, 68?
So in terms of a percent difference, again, when you're subtracting the two and then dividing by the sum divided by 2, so that's basically the average of the sum, it is 14% difference.
Which of the two tests, the two energy equations that you just did, which represents the higher kinetic energy imparted to the arm? The 24 mile an hour test, that's the hypothetical, or the actual test at 29 miles an hour? Which one?
The 29 mile per hour speed with the arm weight of 9.38.
What does that mean, Dr. Wolf, in terms of the testing that you did with the lighter arm, 9.38 pound arm, at the 29 mile an hour test, as it compares to the hypothetical 24 mile an hour test?
It would be more force and more energy in the 29 mile per hour impact test.
Even though you used a lighter arm? Potentially.
Sustains.
And what was your opinion and conclusion as it pertained to the subject taillight using the 29 mile an hour test? What was your opinion and conclusion as it pertains to the subject taillight? Was that consistent or inconsistent with the damage that you saw on the 29 mile an hour test?
It was inconsistent.
Thank you, Your Honor. That's all I have.
It sure was a lot of math in the morning, you guys. What you got for us, Brennan?
May I, Your Honor?
Yes.
Good morning, Doctor.
Good morning.
Doctor, did you have a chance to speak to anybody from the defense this weekend?
Not over the weekend, no.
After you left here Friday?
On Friday, I let them know that I was returning back home, and then I let them know last night that I had arrived, yes.
Did you receive any new information or have any conversation before you came in today?
No.
Now, when we asked you about weight last week, you did not go into any calculations about the difference between the standard arm, 11.86, and the 9.38, did you?
I don't believe we did, no.
In fact, when you testified last week, at the end of the day, you were asked questions by Attorney Jackson about the weight of that arm, correct?
Yes.
And when you were asked about the weight of the arm, Attorney Jackson asked you if you were asked a lot of questions about the difference in the weight of the arm, about 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Do you remember him asking you about that?
Yes.
And you were asked whether you were aware whether anybody had measured the weight of John O'Keefe's right arm. And you responded, I'm not aware of that, no. Remember that testimony?
Yes.
And then you were asked, when you asked questions about whether or not his arm was 11.8 pounds, are you aware of anybody ever just weighing just his arm? And you said no.
Correct.
And finally, you were asked, what is that based on, 11.8? Where did that come from? Remember what you said?
Yes.
I don't know. Remember you answered Attorney Jackson and you said, I don't know where that came from.
Right, referring to, I don't know what source you pulled that 11.8 from.
And so you were suggesting that that is just a number pulled out of thin air, right?
Sustained.
Was that a surprising estimate, 11.8 to you?
I don't know that it was surprising. I don't know what your source is for it.
Well, when you engage in accident reconstruction, you never just take somebody's limb and sever it and throw it on a scale, do you?
I'm not usually doing that part of the analysis, no.
So when you're relying on body weight and different parts of the body, there is strong statistical studies that give you a guide, isn't there?
I would agree with that, yes.
Well, the number's just on the thin air. If you're doing a study and you have to figure out damage to an arm or a foot or a leg, and you have to come to an estimated value or weight, you have to get that information from somewhere, don't you?
I would agree, yes.
So you just make it up out of thin air. You have to find a resource, a reliable, vetted resource. True.
I would agree.
And that's what you do.
In some instances, yes.
Well, in this case, you chose an arm that was 9.38 pounds. Where did you get the support that the 216-pound, 6'1" man would have an arm that weighs 9.38 pounds? Where did you get that from?
Well, it's conservative from the standpoint, if you think about one of the equations we talked about last week, force is equal to mass times acceleration. So if we take the acceleration data from our test and we multiply it by a lighter mass, the 9.38 pounds, it's less force to the arm. So now if you want to increase the mass of the arm, you're now talking about a greater net force to the arm. So it's conservative from a force perspective.
Put aside your story about the force perspective. My specific question is,
So it's sustained. Ask the question differently.
I'll ask you again, Doctor. Tell us where you got the 9.38 pound value from when considering a 6'1", 216 pound man. Where did you get that from so you could be statistically accurate?
It is the mass of the hybrid 3-arm. We saw the photograph that depicted the weight. Again, how you account for that when you're doing the force calculations is you would utilize the acceleration data that we measured, and then you would apply a different mass, in this case, a heavier arm. And I will note, it's the same thing that Dr. Welcher did in his drop test with the hybrid 3 head. He ultimately measured the acceleration of the head, and then to calculate the force, he adjusted the mass of according to Mr. John O'Keefe's mass of his head.
So for the third time, I'm going to ask you a very simple question. Dumb it down for me if you can, okay, Doctor? Where did you get the source to legitimize using a 9.38 pound arm for a person that's 6'1", 216 pounds? Where did your source to say that arm is validated to use for that size man? Where is that?
Again, it's the weight of the ATD arm. That is what the 50th percentile arm weighs. As I mentioned, in our field, it's accepted to utilize the acceleration data, and then you adjust the force based upon an increase in mass.
Is that your answer?
Yes.
Mr. O'Keefe's body weight and size does not put him in the 50th percentile like the 9.38 arm. He's closer to the 95 percentile. Isn't that fair to say?
Correct.
And there is, in fact, the 95 percentile crash test dummy, isn't there?
There is, yes.
Yeah. You chose the 50 percentile, which is shorter, yes?
Correct.
Weighs less, yes?
Correct.
And the arm weighs less. True?
Correct.
The truth is, you have absolutely no study, no paper, no article that supports using a 9.38 arm for a 216-pound man who's 6'1". You have not one reference or study you can offer us right now, do you?
I don't agree with that because, again, if you look how Dr. Welcher did it, he used the 50th percentile in his drop test with the head, and to calculate the force, he adjusted for Mr. John O'Keefe's mass of the head. Same thing is done in this instance with the lighter arm. We adjust for that in the calculations.
So you have one paper, one study. I know the answer to this, so let me ask. You have one paper, one study to support that it is appropriate to use the 50 percentile 9.38 arm for a person who is 6'1", 216 pounds. I won't ask you again, but if you can answer this once for me. Do you have one paper, one study?
So I'll take out the commentary. Can you answer that question, please?
Sorry, can you repeat the question?
You have one paper. Give me a name, an author, one paper, one study that supports using a 9.38 arm, 50th percentile, when you're doing a crash test for somebody who's in the 95th percentile who weighs 216 pounds and is 6'1". One paper, sir.
I don't have a paper because Dr. Rentschler is addressing the forces and the injuries to the arm.
You talked about, however, would you come up with the number 11.8? Like it was something that is curious or foreign to you, right?
Objection.
Sustained.
Are you confused how the number 11.8 would come up?
Objection.
I'm going to allow that.
I'm not confused. I don't know your source for it.
When you do studies, would you agree that the head has a similar weight to the arm and that the weight of an arm would be about 5.48% of a person's body weight?
I'm sure that there's various studies out there that talk about that. Could be one particular study.
Well, let's talk about one study. What do you think? You're the engineer, you're the expert. When you're weighing an arm by percent, what is the percent of the arm of the total body weight?
I don't know as I sit here today off the top of my head, no.
I'm sorry?
I don't know as I sit here today off the top of my head.
Well, if you don't know the percent of body weight of the arm compared to the whole body, how would you ever come up with a number for the arm?
Well, from the work that I've done with Dr. Rentschler in this case, dating back to last year, it's my understanding that his calculation for the arm was approximately 11 pounds.
So you're relying on somebody else's study? You're doing an independent assessment of the evidence, and you're relying on other people's math? Is that what you're telling us?
I don't agree with that because, as I've mentioned numerous times, Dr. Rentschler and I worked as a team on this case. You can't separate the reconstruction part from the biomechanical part. It's an integral part that works together on it.
Would you agree that the arm is about statistically vetted, that it's 5.48% of the total body weight? Would you agree with that?
It sounds about right, but again, I
Okay.
don't have the percentage
So
off the
if
top of
you
my head.
take 5.48% of a 171-pound man, which is the crash test dummy you were using, the 50 percentile, what do you get?
You said 5.48%?
Yeah,
Just over 9 pounds,
okay. Close to 9.38?
9.37.
Okay, now when you have 216 pounds, 5.48%,
11.8.
11.8. Sound about right, doctor?
By that calculation, yes.
Okay. Now, you said you had some confusion where I'd get that number from, this 11.8. Do you remember that?
Yes.
Right. A search related.
And when I throw out that number, is that the first time you heard of that number?
The 11.8?
Yeah.
Yes.
Or 11, is that the first time you heard of it from anybody, 11 pounds? Is that a new number to you?
I don't understand your question.
Well, you're saying that when Attorney Jackson asked you, where did Brennan get those numbers from? You said, I don't know. Remember that on
Correct.
Friday? Do you know where I got the number 11 pounds from?
11.8
Yeah.
or 11?
11.
As I just mentioned, last year, I believe I testified in a previous proceeding that it was about 11 pounds.
Yes. Your testimony, 11 pounds. Your prior testimony, right?
Yes,
You testified before under oath in this case, didn't you?
correct.
And when you testified under oath and you were giving a general estimate about the pounds of Mr. O'Keefe's arm, based on your experience and your training, you said it was around 11 pounds. Those are your words, right?
Correct, yes.
Under oath,
Yes,
right? You can't delete something that's under oath, right?
Sustained.
And so when you feigned confusion on Friday about this 11 pounds,
Sustained.
so when you answered questions last Friday about wherever this 11.8 pounds came from, you weren't so confused about that because you've used 11 pounds before yourself, haven't you?
yes, but again, I don't know where you got that 11.8 from, so
Well, we just did the math, didn't we?
yes,
Okay. And you used a calculator to help you, didn't you?
I did,
The
yes,
calculator works.
yes,
Okay. You said you wouldn't calculate the difference, but you did. And so what you just went through this exercise is you divided that difference, that 2.48 pound difference, right?
correct.
And then you divided it by 11.86. Divide 2.48 by from the 9.38.
Okay,
What percentage do you get?
26.
Would you agree with this statement about whether the arm and body weight, comparing the weight of the head to the arm, would you agree that the head and arm are actually almost identical because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight? So for someone who weighs 216 pounds, that's about 10.8 pounds. Would you agree with that?
I didn't do that calculation, so
Didn't ask you. I'm asking if you would agree with that.
can you repeat the question, please?
So ask the question.
Does the arm weight weigh the same as the head? Or the arm does weigh the same as the head, almost identical because your arm, just one of the arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. Would you agree with that?
I haven't done the calculation, but if the math checks, then yes.
Okay. Would you agree with this statement? The heavier the object, if it gets hit center mass, that's going to be even greater force because that is more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body. Do you agree with that?
I'm going to allow the question.
Do you agree with that?
Yes, and I think I described that a little bit earlier. Is you would increase the mass, you multiply it by the acceleration. That's going to increase your force. Force is equal to mass times acceleration.
Right. So mass has a direct correlation to force. You agree?
Correct.
So therefore, the heavier the object, if it's colliding at the same speed, will create more force than a lighter object. You'd agree with that, wouldn't you?
Correct. More force on the arm. Yes.
Right. So weight matters, doesn't it, sir?
Yes.
Force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get the same force. And so inevitably, you change the mass, you change the weight, same speed, it changes the amount of force.
Correct. Yes.
Yeah. Okay. When you did calculations in this case, you never took the estimate of 11 pounds, although it didn't exactly calculate the 5.48. You never took that 11 pounds and determined the percentage difference between the mass in that arm and the mass in a 9.38 pound arm, did you?
No, I did not.
You didn't include it in any of your PowerPoints.
No.
You didn't explain it to the jury that there's a difference in weight matters.
Again, that's something that Dr. Rentschler is going to discuss.
I'm asking you because you testified, you gave opinions, you got a PowerPoint. Did you explain to the jury about the difference in force when there's a change in weight? When you did all your PowerPoint and calculations, did you break it down for them?
Well, I think it was certainly stated. I mean, I know that we went over Newton's second law, force is equal to mass times acceleration, right? So if you increase that mass number, it will increase the force.
When you were putting up your PowerPoints with the speeds, did you explain to us that there's a difference when you change the mass so that if you used a lighter arm, there would be a difference in force? Did you explain that to us in any of your slides?
I don't know that I explicitly stated it, but again, that's why we went up to 29 miles per hour to account for that difference in weight.
Were you trying to inflate the force for the speed of test so it looked like the collision had to happen at a faster speed to cause a certain amount of damage? Were you doing that intentionally?
No.
You didn't overstate the mass. You didn't use an arm that was 14 pounds that would have created the opposite illusion, right? You used a weight that was lighter than Mr. O'Keefe's estimated arm.
Right, because again, it goes both ways. If you increase the mass of the arm, you increase the force on the arm. So there's going to be more force acting on the arm.
Let's talk about your studies with Mr. O'Keefe's sweatshirt and his arm, and you gave some opinions about what you would expect for damage to his arm. When I asked you on Friday whether you had any support, any vetted journals, learned treatise, any support whatsoever about whether you should use a crash test dummy arm for these types of studies, you didn't have any support on Friday. Do you have any today that you can refer to?
No.
Putting aside the fact that you have absolutely no professional studies or journals to support that you should be using a crash test dummies arm for these type of tests, are you aware of the expert literature in this case that the opposite, you specifically should not use crash test dummies when you're trying to do this type of analysis on clothing and a person's body? Are you aware whether that exists?
I'm not aware of those studies, no.
As a inquisitive engineer, wouldn't you want to know if there was legitimate studies in your world, in your profession, that suggests or states that you should not be using crash test dummies to determine injury to the arm as far as lacerations? Would you want to know that?
I think, again, you're getting confused between my role and Dr. Rentschler. Can I finish, please?
No.
Okay, so
No.
no comment, Mr. Brennan. Answer the question.
No.
I wasn't addressing the lacerations or the abrasions to the arm, sir.
You had photographs and you were opining that you would have expected or you would not expect there to be abrasions or cuts on that clothing in your test A and B, didn't you?
There were no holes or cuts in the material, no.
I understand, but you offered opinions. Didn't you offer to the jury an opinion that the abrasions on Mr. O'Keefe's arm were inconsistent with your tests in A and B?
The cuts and the holes are inconsistent.
Sir, when you are assessing cuts and holes on clothing, you need to make sure the predicate as a basis that you're using the right properties, right?
I would agree with that.
And so if there was literature directing that you should not use a crash test dummy to assess injury on an arm, would you follow that instruction or would you do it anyways?
Again, you keep saying injury to the arm. I was looking at what happens to the material when it makes contact with the tail light.
A crash test dummy's arm is harder than a human arm, isn't it?
Yes.
You push a human arm, it's like an indent. You can push in, can't you?
Yes.
And that property of pushing in, if a cloth is on it, it is easier for a cloth to tear pushing in than if it's hard.
How's this helping his
Isn't
case?
it?
I don't know that I agree with that.
Well, do you disagree with that?
Well, the hybrid arm is a vinyl flesh, so it's not rigid.
Do you disagree with what I just said?
Can you repeat your question?
Sure. Human arm, softer than the hybrid, yes?
Yes.
When you push it, you can push in, much different than the hybrid arm, which is stiffer, yes?
I don't know what you mean by much different, but there will be a difference, yes.
Well, is it a noticeable difference to you if you push a hybrid arm as opposed to a human arm?
Yes.
When you push a human arm, it indents, yes?
Correct.
And so if you push with cloth on, the cloth indents, yes?
Correct.
Which creates an easier, it creates an easier tear in the fabric with less force if you can push in as opposed to a hard arm. Would you agree or disagree with that?
I would agree with that.
So when you're replicating studies and giving opinions about a person's arm, a real person's arm, using a hybrid arm doesn't seem to be an appropriate standard, does it?
I don't agree with that because, again, when the taillight breaks in the test, the arm is now moving with that taillight. So it's, again, like we talked about on Friday, you'd somehow have to have those fragments accelerating at a greater velocity to penetrate that.
We're going to get to that, but I'm talking about the stiffness. Let's get back to the appropriateness of using a crash test dummy. Now conceding that a human, it pushes different than the crash test dummy, would you agree that a crash test dummy is not an appropriate tool to use when determining tears in clothing on somebody's arm? Would you agree?
I don't think I would agree with that, no.
When you used the crash test dummy in test A and B, that was the 5'9" dummy.
Yes.
And Alexis.
When you consider tears to clothing, you bought a new sweatshirt that was similar to Mr. O'Keefe's, an extra large sweatshirt.
Don't know if I recall the exact size, but I think one of them might have been extra large.
And then you bought a second one that was medium. So when you used the smaller dummy, you weren't actually using Mr. O'Keefe's size of extra large. You used a medium sweatshirt, yes?
Yes.
Because it was a smaller dummy than the size of Mr. O'Keefe. That's why you needed a smaller sweatshirt, yes?
I think it was more or less just what we could get our hands on.
Well, you had an extra large and a medium. You didn't put the extra large on in test A and B, did you?
I don't recall off the top of my head what sizes were on each test.
Okay, could we show a picture of A to remind Dr. Wolf?
I don't understand what he's doing here. How is this helping his case at all?
And while she's pulling that up, is there a difference between, so see that's how that's blue? You see that's medium?
Yes.
So the blue ones you use to test A and B, correct?
Correct.
The smaller crash test dummy than Mr. O'Keefe, the 5'9" crash test dummy, yes?
Correct.
And then when you use Randy and brought him into the scene, you used the extra large, the gray one.
Correct.
Right, so you used a different one because it was a smaller anatomical doll than the size of Mr. O'Keefe, yes?
We used different sizes. The material blend was the same.
This was new.
Correct.
The extra large you put on Randy was new.
Correct.
Did you consider that the wear and tear on Mr. O'Keefe's sweatshirt, the extra large sweatshirt he was wearing that night?
The wear and tear?
Yes, the wear and tear.
No.
Did you ever consider the differences between a brand new sweatshirt and one that had been worn?
No.
Had you ever had clothing, sweatshirt you used repeatedly, maybe put in the dryer, wears it down? Sometimes you can get holes more easily. Did you do any type of analysis on that whatsoever?
No, I don't allow that.
Any type of analysis whatsoever on the age or whether it's stretched the same, anything like that?
No.
No variables whatsoever on the sweater, did you?
No.
Does it matter whether or not the sweatshirt is tighter or looser or how it fits the body? Is that any part of your consideration?
No.
Have you ever done testing like this before for clothing?
In terms of impacting a taillight?
Yes.
No.
So this is the first time ever that you've done this type of analysis and offered an opinion in front of a jury on this?
Specific to impacting an arm with a taillight, yes.
Before you decided to come in and give an opinion, did you take any study or look at any journals on fabrics?
No.
Did you consider any of the variables that one would want to consider regarding fabrics before you came in and gave this opinion?
No.
Did it concern you when you were coming in to give a professional opinion about something you've never done before, whether or not you were studied in the area before you did it?
Good job, Haley.
Well, I think I relayed my observations from the test, right? I certainly explained how we set up the arm, how the arm was closed. You all obviously saw the impact testing to the arm, so I'm relaying my observations from the test that we did.
Did it concern you that you were coming in to give an opinion on something you have never done before, and that you did absolutely no study on fabrics or any of
Textile
other
expert.
people's analysis on fabrics and cutting? Did that concern you?
No.
So you were comfortable just coming in with no experience in this whatsoever, without even studying or doing any research? You were comfortable to come in and just throw out an opinion?
No, again, and Dr. Rentschler is going to address part of this. Again, we worked as a team, so there's a synergy between the two of us.
Well, putting aside the synergy, you're the one on the stand under oath, yeah?
Correct.
The other one testifying, giving opinions to this jury, yes?
Yes.
The other one asking them to rely on your experience and training, true?
Correct.
The other one asking them to rely on your judgment and your effort to be accurate, yes?
Yes.
So when you give the opinion, you have a personal responsibility to support that opinion, putting aside Dr. Welcher or Dr. Rentschler. You have a responsibility for your opinion, don't you?
I would generally agree with that, yes.
Generally?
Yes.
Well, when wouldn't you? When would not be general? Don't you have an obligation every single time you take the stand and give an opinion to be supported, valued, vetted?
Yes,
Every single time?
and again, Dr. Rentschler is addressing those abrasions and lacerations, which certainly correspond to the material.
Right. But you didn't wait for Dr. Rentschler. You offered a number of opinions to this jury. You personally, under your name, you came in and presented yourself as an expert in this subject.
I
You,
hope so.
didn't you?
Correct.
So putting aside Dr. Rentschler, his opinions, do you stand behind your opinions?
Yes.
Okay. And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever?
Yes.
You wrote a report back on February 12, 2024.
Correct.
In February 12, 2024, do you remember talking about injuries to the arm and damage to the taillight?
Generally, yes.
Okay, that's fair. Do you remember writing in a report, it is significant to note that the injuries have been classified as abrasions and analysis of the autopsy photographs indicates minimal bleeding or lacerations of the dermis?
So the report that you're referring to is a joint report authored by myself, Dr. Rentschler, and Mr. Scott Klein. So that would have been a portion drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else's, right? I'll move on.
The objection is sustained.
I'll move on.
The objection is sustained.
Did you agree with that?
Sustained.
Did you write or endorse these injuries would not result from impact with a non-damaged tail lamp cover and the amount of force required to fracture the tail light cover?
So I'm going to see you in sidebar.
By the way, Dr. Wolf, he's lucky he's cute because his breathing in the mic is driving me crazy. Yeah, so a lot of people are drawing the same conclusion here. Like, so why is Brennan going down with these questions? Because it's not making his argument look good, right? He says, oh, so a human arm is squishy and Rescue Randy's isn't, right? It would be different, right? And it's like, yeah, you saw the damage on the dummy, which would mean it look even worse on a human being, even worse. on a human being because we're, again, squishy. So not helping your case at all. And what's the other thing that the shirts. As I forget who pointed that out in chat, but yeah, absolutely. If that was a shirt that John has worn often, it's worn out. It's going to tear even easier than a new shirt that they had. Well, look at what happened to the brand new shirt that hasn't been, worn and washed a bunch. It did not help this case at all. At all. I don't even understand why he did that. Oh goodness. Let's see. Lady in Gray says one of the persistent note takers looks confused during the flurry of objections. Oh, another thing before I forget. So when Brennan moved from the podium to like lean on to that railing because he is so cool like that, it kind of looked, because he obviously was not listening to anything Dr. Wolf said. He had no intention of listening to anything. It was very apparent. But he did keep looking at the jury, and he kept looking like in the same direction. And I'm wondering if there's somebody sitting on the far right that he has his eyes on, to see how they're responding to what. I thought it was very interesting that he did that. Yeah, I guess Hank did say that, right? I don't understand the shirt argument at all. Like, what? Every time he gets up there, he throws all of his witnesses' testimony under the bus. Like every single time. It's remarkable. Tech, hello and welcome to the chat. I agree. I do think it's going to be a hung jury as well. That's what I think. I don't think either side can sway them to be full on, but you know what? We'll see. Juries can be very surprising. But I do think they're going to deliberate for quite a few days, that's for sure. I would expect them to. Angie said Hank argued dummy tests getting foot hit and shoe coming off was accurate, but argues against himself. The dummy test is not accurate. Right? What about Dr. Welcher and his dummy he used, which was like the same thing, who had to make those calculations to account for the mass difference. I think that was right. I don't know. I'm not the best at that kind of math and science. And like, it doesn't bother me that the shoe didn't come on and off. It is known that the majority of the time, shoes are going to come off when you get hit with something like that. So it doesn't mean always. So I don't really care too much about the shoes. But Simone, I think that Hank will ask Santa for a crash dummy for Christmas this year, and he will get a busted fire hydrant. Oh boy, yeah, RTP, yeah, not looking great for him. Jim, I very much concur. I think there will be a third trial if it's a hung jury. I think it's ridiculous. And I hope the people who live in that area just protest the shit out of them, because this is preposterous that even made trial number 1 and then 2. And what, they're going to come back with third trial with even less witnesses and even less evidence because everything they presented has been super tainted. I don't even know how they could get a third trial, to be honest. You think Jackson should have ignored all this stuff? I mean, well, maybe, but maybe not. I don't know. But I think that Brennan did himself no favors. I mean, I could have went without Jackson doing all that math. Like, I still don't know or care. But Scorpion says, and went with John was never hit. You got lucky and a good cop. End of story. I mean, I don't feel like justice is being done in any way. And that is very, just because you're on the, there's reasonable doubt, or you think she's innocent or whatever. I don't think a single person is like, doesn't want John O'Keefe to have justice. We just want it to be proper justice and presumably the right person. So I do feel bad for, for him and his family and his mom. I feel very bad for her. Jim says, if this case doesn't demonstrate reasonable doubt, no case would nonetheless. That is absolutely accurate, Jim. Absolutely accurate. I mean, there's so many, oh my God, there's so much reasonable doubt with every single little thing about that's coming. And Brennan being all like, the defense and Dr. Wolf are trying to trick you, jury. They're trying to trick you. Sir, you have tried to pull the wool over the jury's eyes how many times? Like majorly, like 3-4 times, where it was like outright obvious, not including all the other subtle ways you've gone about that. Oh my gosh, come on. I swear. That's true. There is the good old FBI. The good old FBI is always watching, I'm sure. Right? Oh, Scorpion. You got the kids that say the Lexus and no Jeep with a plow. Keep the defense simple. I mean, do I think the defense is doing the best job? I think they're doing a great job. They don't have to put on a case, but we're here, so I feel like we could use some other things, but like, where's the ER doctor? Oh.
You were asked questions about impact with the taillight. And in fact, in one of your answers to me today, you talked about after a vehicle collides with a pedestrian, there's continued movement between the vehicle and the pedestrian, isn't there?
Correct.
And so while glass or plastic that shatters from a taillight might not impale clothes of the skin, would you agree, if your dummy wasn't restrained, when the Lexus collides with the dummy, there'd be continued contact for some time, extended contact between both the dummy and the taillight?
Well, the arm, as is demonstrated in the test, would be moving at roughly the same velocity as the vehicle.
Yes. And don't you think that the vehicle would continue to drag the arm until the body either was thrown or spun off? Would you agree with that?
At some point, they will separate, yes.
At some point, but before at some point. What I'm asking is, at the collision, when you see all the taillights shatter, right, wouldn't the Lexus, if it continues at that speed, say 24 miles per hour, for example, it would continue to drag with that dummy's arm longer than is shown in those experiments because the dummy is restrained?
Sorry, can you repeat the question?
Yes. Would you agree that if a Lexus is backed up at 24 miles per hour and hits the dummy's arm and the taillight shatters, if the dummy wasn't restrained and moved regularly, it would extend the contact between that shattered taillight and the dummy's arm? Would you agree with that?
It would move with the vehicle until it got pushed out of the way, just move to the side, yes.
And so what you're saying is it would move with the vehicle but wouldn't touch the vehicle?
Well, in the one test, if you remember, because of the restitution effects, the arm reached a speed of over what the impact speed is. So in some instances, it actually might move at a speed greater than the vehicle.
Fantastic. In some instances, would it move slower and be dragged by the vehicle's broken taillight?
Dragged?
Yeah,
I don't know
so
if
when
I
say
understand.
drag, push. How about we use the word push? Pushed by the broken taillight. Could that happen?
The arm would move with the taillight until it moves out of the way.
So you're saying it would move with or faster, but never would slow down where it gets pushed by the car.
It's moving with the vehicle, sir. I don't understand your question.
Well, you said it moved with the vehicle. Sometimes it moves even faster, suggesting space between the broken taillight and the arm. That's what you're suggesting, right?
Correct.
So it can move with, it can move faster. Can it ever move slower and the vehicle pushes and drags against the arm?
I mean, it might be able to move a few miles per hour if it doesn't have as much of a center of mass hit, but it's still going to move out of the way because it's on a joint.
I understand, but before it moves out of the way, could it be pushed by that broken taillight? That's the simple question I'm asking you. Could it be pushed by the broken taillight?
Just moving adjacent with the taillight, just moving along. Yes.
Would you agree with this? If you have an arm struck at 25 miles per hour, significant more damage that taillight shatters, hits and moves forward into arms, parts of taillight pushed into arm as vehicle pushes forward and pushes arm out of the way. So the word push, would you agree with that general characterization that the broken taillight can, in fact, push the arm? Would you agree with that?
Generally, I guess, again, it would move with the vehicle, the arm together.
Not move with. I'm asking you if you would agree about pushing. Would you agree with that?
As long as we're on the same page about it, it's pushing the arm, but it's with the vehicle. They're moving together. So, but in essence, yes, the arm is being pushed due to the fact that there's a force on it.
And the pushing could have that arm in contact with the broken pieces of a taillight if the taillight broke, correct?
Just moving at a common velocity.
The operative word here is push. And so do you like to agree with me or you could disagree with me? Can the broken taillight push the arm so it contacts and provides force against it? Could that happen?
Yes.
When you were showing those photographs today regarding test F, now you use Randy in test F, right?
Correct.
How tall is Randy?
He's 6 feet.
And he weighs 200 pounds?
Correct.
So still 16 pounds less than Mr. O'Keefe, yes?
Correct.
And you keep referring to Randy as a crash test dummy. Randy's no dummy, right? He's a mannequin.
He is, but he signifies basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
I don't want to misrepresent Randy. He's not a crash test dummy, is he?
Well, it wasn't used for biofidelic purposes. It was to, again, what happens when you have 200 pounds of mass strike the vehicle.
So when you've been referring to Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
I don't know that I agree with that.
So you think that Randy is a crash test dummy? He's a certified, approved crash test dummy.
No, and I think I made it very clear that there is no instrumentation on it, right? And one of the reasons why I mentioned that is those ATD dummies are $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis for you, but I want to be clear.
Can you?
He's a mannequin. It's used by firefighters and drills pulling a body dead weight out of a house to replicate certain scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate studied crash test dummy, is he?
I don't agree with that because, again, we use that type of dummy in all different types of tests.
There's an H395M PED, which most closely replicates John O'Keefe's size and body, isn't there?
Correct.
You didn't have that when you did your test, did you?
No.
When you do crash tests, you can put a magnetic control on the crash test dummy, so upon impact, it releases and is thrown. You could do that, couldn't you?
That is one way, yes.
Right. So that way you don't have to put the dummy on a forklift, and then it creates a different scenario than real life, correct?
That could be one way that you could do it, yes.
It doesn't impede any roll or drag when the dummy's hit. That's one reason you would do that rather than a forklift, yes?
Correct.
Also, it might show some throw, which could lead to other type of damage like holes in clothes, yes?
Correct.
But you didn't use the magnet, you used a forklift.
Because again, the purpose of the test was to evaluate, we talked a lot about those timeframes, right? That 10 millisecond window. It's to look at, from the vehicle damage perspective, what happens to the taillight, right, in that interaction. And then ultimately, what is the acceleration that the arm experiences in that 10, 15 millisecond window, right? What happens 1 second after, 2 seconds after? Again, that wasn't of concern for me in my analysis.
You didn't use a magnet, you used a forklift, right?
Correct.
And when Randy went for a ride, you didn't expect him to break off the string and slide across the street, did you?
We didn't expect him to.
You didn't expect him to be thrown. You didn't expect the string on the forklift to break and then Randy to go flying. You didn't expect that, did you?
Oh, I certainly expected that.
So you expected a throw with that?
Yes.
And the street has hard concrete and it has a lot of irregularities to it, doesn't it?
It's asphalt, yes.
Yeah. And the photos that you were shown today on redirect examination, did the defense show them to you during your direct examination? Any of those?
No.
Ms. Gilman, can you pull up that last exhibit with Randy on the ground? I think it's exhibit 221. Okay. And so this is Randy, right, doctor?
Yes.
Zoom in a little bit, please. What's that red thing near his shoe?
Appears to be a fragment of the taillight.
Can you zoom out? Could you go back an exhibit to the one before? Can you zoom in? Did you see any taillight fragments on his body or in his clothes?
I can't tell from here.
Could we have the exhibit before, please? Can you tell from here?
Yes.
Okay, it's on his back or his
And
stomach.
finding taillight fragments on the clothes after a collision, that's not unique, is it?
Look who's here to join us this morning.
Unique? No, it's possible.
Hi, Terry True Crime.
According to this, it's probable, yes?
In this test, that did occur, yes.
Do we have exhibit 201D, please?
It's not him and Randy.
Do you know what this is, doctor? Did you see this picture in your analysis?
Don't know if I recall that specific photograph.
Do you know this is taillight shards found in Mr. O'Keefe's clothing?
Objection.
Sustained.
Did you consider this photograph during your analysis before you gave your opinions regarding cuts and tears and lacerations?
No, sir.
Can you take that down, please? When you did your analysis, did you know that a drinking straw was found on the concrete on the street in front of 34 Fairview?
I don't know if it was on the concrete, it might have been on the asphalt, but I do recall a drinking straw, yes.
Did you know that there was a glass found near Mr. O'Keefe? Could you put that up, please, Cindy?
Objection.
Sustained.
Did you talked about cuts and injuries. Did you?
Sustained. It sounds like it's beyond the scope.
Very well. When you did test D, did you say the peak acceleration was 780 Gs?
Your Honor, may I refer to my notes?
Yes.
Page 11 of your report.
I think I lost an exhibit.
He's so calm and cool and collected.
I know, right?
Okay.
Is that what you described it as?
For test D,
Yes.
the acceleration of, we talk about the hand,
Yes.
780 Gs, yes.
780 Gs. Okay. When you did your comparison before you gave your opinions, you showed us a scuff on the exemplar vehicle, photo 77.
Beyond the scope, Mr. Chairman.
I wonder if we can get Rescue Randy on the
Two more
show.
questions, Dr. Wolf. You showed us holes in Randy's sweatshirt from test F. You remember that?
Yes.
And you talked about what you would or wouldn't expect in a collision as far as holes. And did you say something like that was inconsistent with Mr. O'Keefe?
Yes.
That's what you said on redirect, right?
Correct.
Okay. Did you consider whether there were holes in Mr. O'Keefe's sweatshirt separate from the holes in the arm?
Sorry, can you repeat the question?
Yes. When you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
Well, I know that there was cutting to the,
May I approach and retrieve the exhibit, Your Honor?
I think so. Scorpion. I didn't realize they're still like $100,000. That's crazy.
Yeah, they're expensive.
Those animatronic
You ever look at the
sexy
back
time
of the
dolls
sweatshirt
are like cheaper than that.
The back of the sweatshirt other than the right arm and you formed your opinion?
I don't recall.
Take a look at the back. You see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look. I'll direct you to here. You see more than one hole in the back of Mr. O'Keefe's sweatshirt.
Yes.
When you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Of course you didn't, Hank.
Sorry, can you?
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground and had broken taillight shards in his clothing, did you?
No.
I have no further questions.
Yeah, just a moment.
By the way, I'm seeing Kevin has posted over in Discord some rugged Rescue Randy mannequins that are only like $2,000, $3,000. So you can get your own Rescue Randy Mannequin, 185, one for $2,800. And those are great.
You were asked by Mr. Brennan, give me one name, very dramatically, of someone.
Objection.
The objection sustained.
You were asked, give me one name to support using a 50 percentile hybrid 3 in testing forces on a 216-pound man. Do you remember that question?
Yes.
How about the name Judson Welcher? How about that name?
So the objection sustained.
Did Judson Welcher use a 50 percentile hybrid in his drop test?
Objection.
So that's sustained as to form.
What did Judson Welcher use in his drop test?
A hybrid 3 50th percentile male, the same that we use in our testing.
Oh, sorry. Polly was sharing. I'm not capping.
You were also asked whether or not using that hybrid 3 arm with the same speed would have an effect on the force equation, on the force calculation, correct?
Correct.
And you agreed it might have a small effect on the force calculation, correct?
So sustained as to form.
This is just foundational, Your Honor.
Sustained as to form.
How did you answer that question?
I'm sorry, can you repeat the question?
Sure. Let me ask it this way. In the 29-mile-an-hour test with the hybrid 3 arm, were you going faster than 24 miles an hour?
Yes.
And what was the calculation again on the increased force that would be exerted on the taillight, on the arm, area of the taillight? 14%?
Yes.
Objection.
So sustained.
How much, what was the percentage that you calculated? The increase?
14%.
And did you find damage, even with the increase of 14%? Did you find damage on that exemplar taillight consistent with the extensive damage on the subject SUV?
Objection.
All right.
No.
Can we have 201D put up one more time? Mr. Brennan just asked you if you made note of these little red pieces, correct?
Correct.
Do you have any idea the size of those pieces? As you sit here.
Not without a scale of some sort, no.
So as you sit here, do you have any idea what the size of those pieces are?
I couldn't tell you as I sit here today, no.
No idea if they're a foot long?
Objection.
So the objection sustained.
Oh. Looks like there's
You were
enough
asked
brandies for all
when
of us.
shown this picture if you accounted for this in terms of damage to the garment, the sweatshirt, right?
Correct.
What if I told you those were?
Objection.
So the objection's sustained. He said he doesn't know the sizes. That's the end of that, Mr. Jackson.
I realize he said he doesn't know. He was
That's
asked
the
questions.
end
Your Honor.
of that, Mr. Jackson.
Oh,
Bev.
rude.
You have the, Mr. Wolk, do you have the picture of the 10? The TIN 10, the little round 10? Do you see that 10?
Yes.
Are you aware that all those pieces are inside that 10?
Objection.
Sustained. And jurors disregard that.
Did you ever see this 10 in your analysis?
I do recall seeing, yes, in the evidence photographs of all the fragments, yes.
In your experience, are very large pieces or very small pieces put in little tins, about 2 inches wide?
Sustained.
You were asked a question about the arm being pushed by the taillight. Asked a bunch of questions about that, right?
Correct.
You indicated, what did you say in terms of the contact by a vehicle pushing an arm.
It's going to move with the vehicle until it separates.
In your testing, how long did it take the Hybrid 3 arm to get up to speed of the vehicle in the 24-mile-an-hour test?
About 10 milliseconds.
I'm sorry, say that again, louder.
10 milliseconds.
10 milliseconds, correct?
Correct.
So when you say the arm is being pushed, it's being hit, correct?
Objection.
The objection sustained in its trial.
In every one of your tests, every single one of your tests, did any taillight fragment tear a hole in the sleeve of the shirt that you were testing?
No, there was no holes, punctures, fraying, nothing to the material.
Was there ever a defect in that garment in any of that testing other than the road rash that we saw in the 29-mile-an-hour direct impact?
That the only test that showed the holes and the abrasions was that full-on hit where the body was sliding on the ground. There was no test where the taillight caused any type of punctures, holes, or fraying to the material.
And in that test, what happened to the back of the license, the test license?
Destroyed.
You heard any follow-up questions?
Okay, go ahead.
I've never seen so many redirects and recrosses ever.
I know.
Ever. What are they doing? Going for a sidebar? Ugh. Good morning, Terry. I would like to just go on the record. I don't know if Elbow Feet's listening because I haven't seen him say hi in the chat, but I'm just going to go on the record and say that he was right. I don't get to say that very often.
Wow.
I ran out of creamer this morning and he was like, oh, you should put some chocolate milk in there. And I don't really like chocolate milk. He's like, you should do that. It'll be delicious. And I'm like, no, I'm not going to do that. I'm just going to use my boring, original powdered coffee creamer because that's the in case of emergency, break glass up, and it's been crap all morning. So I was like, okay, let me try the chocolate milk. It's freaking delicious. It's so good. It's so good. So
Really?
I'll go on the record and let everyone know that he was right. He'll appreciate that later.
I don't
Anyway.
drink milk of any kind.
I don't either.
So to me, it just sounds. I would put a Hershey's Kiss or some chocolate and then some of the powdered stuff, maybe. Chocolate milk.
Oh,
Uh-oh.
there he is. Look who
There
popped
he is.
up. I'm right a lot. You were right. Anyway,
Let's not get
let's-
cocky, Elbow Feet. Don't be a
Let's
hank.
get back to what we've heard so far this morning. I think Jackson coming back and being like, well, but Mr. Welcher, Dr. Welcher did this and had the same thing. Like he's doing a really good job of being like, we don't know what Hank was talking about. Remember his witnesses? Wild.
On redirect, you again talked about the impact between an arm and the broken taillight.
Correct. Yes.
And I had asked you on cross-examination or recross-examination whether that broken taillight could push the arm, which of course would create force or friction, yes?
Well, once it's moving at a common velocity, I'm just not understanding your question then.
If it's not a common velocity, if the broken taillight is,
Ask the question.
if the broken taillight is pushing the arm, which would mean the broken taillight is going at a faster speed than the arm. If it pushes the arm, the broken taillight can come in contact with the arm, can it?
It's moving with the arm, sir.
Okay, let me ask you this. Would you agree with this? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So if you have the taillight coming in, it's hitting the arm, it's moving forward into the arm. Do you agree with that?
Objection, the source.
Dr. Rentschler, do you agree with that?
Objection.
His name's Dr.
I'm going
Wolf.
to
Get it
allow
right.
Strike source.
Do you agree with that?
I'm sorry, can you repeat?
I can. If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage. Specifically, if there's a taillight that shatters, so you have the taillight coming in, it's hitting the arm and it's moving forward into the arm. Would you agree with that?
Objection.
I'm going to allow it.
In reference to the greater damage, are we talking about damage to the arm?
Do you agree with that phrase?
The best way I can characterize is it's moving with the arm, sir.
So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way.
Objection.
Do you agree with
I'm
that?
going to allow it.
No, you need to vote. I need to vote.
First of all, his name is Dr. Wolf with an E. Brennan. I like how he didn't call you out like that crazy Devers lady. You got super butthurt about her own name. Yeah, Hank is just coming and he's just trying to confuse everything, which is usually what defense attorneys do. He is a defense attorney. But I just don't understand. I don't understand.
Once again, I know we've said this before. If this is your first trial, your next one is going to be a big letdown, potentially, because they're normally not like this, right?
Right. I mean, gosh, the next one we're watching is Lori Daybell, who's representing herself, which is like the usual kind of like crazy. Like it doesn't happen very often. It's always a crazy experience. It's going to be so tame compared to this. Like,
It
it's
is.
hard for me to even wrap my brain around. Like, right. I don't understand. It's very frustrating. Dr. Wolf is doing a great job because I'm just over here like my brain hurts. I'm over this. I'm ready to move on. I don't even understand what we're arguing about. The vehicle was the back of it. I just don't understand.
He is holding his composure so well.
I'd be on the stand and be like, you dumb?
I'd be like, really, dude?
Oh, hey, PG.
I'm going to read this one more time, okay?
Oh,
Okay.
okay.
Would you agree? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Would you agree with that?
Again, my area of expertise is not injuries to the arm, so whether or not those fragments would be embedded or cause any type of damage to the arm, no. But what I would say is that I would agree with the taillight being pushed into the arm. It's going to cause the taillight to fracture, and then the arm will move with the taillight.
When you do a demonstration, isn't this exactly what you see? Could you play E again for me? Isn't this exactly what you see? Play that, please. And now, stop, please. If Randy is not restrained by a forklift, he is going to move with the car, correct?
Well, if it's just the arm, his arm's going to get accelerated and move, and then his body will be there still.
And that broken taillight, if Randy is not restrained on a forklift, is going to be pushed, like it says, by the broken taillight, isn't it?
It's going to move with the arm.
Thank you.
All right, so jurors, we're going to take a morning recess. We'll see you in about 20 minutes.
They're going to do a voir dire on Dr. Lapsoda. But here's so his argument of, oh, the tail light and the arm. So was he just implying that there should have been tail light shards embedded in his arm?
That's what I'm kind of gathering.
Like, okay. Oh my goodness. Oh, in several places. He would have jelly arm for sure. Dr. Flex Soda. I didn't notice the court reporter is dressed very brightly today.
All right, so we're not
like
going to do the voir dire right now of Dr. Lapasada because everybody needs a break. What we'll do is we'll take the 20-minute recess. Who's doing the director, Dr. Lapasada? Is that you, Mr. Jackson?
Yes.
All right, so what I would ask you to do is not do anything on your direct examination with Dr. Lapasada that involves the mention of dog bites or the evidence regarding motor vehicle experience, because we still need to have the voir dire. But I don't want the jury sitting out there any longer than need be, at least until the luncheon break. So without that, how long will it take you? Can you use the hour?
Credentials, but Your Honor, half of her credentials are the fact that she's an expert in dog bites and an expert in motor vehicle. And I give her education, training, background.
Okay, is that all in her resume?
It's all in her. It's all going to be in her direct examination.
No. My question is it in her resume? Has the Commonwealth received notice regarding the dog bite stuff?
Commonwealth has received the same resume that the court has received. I don't know specifically what her resume says about dog bites. I don't think it's specifically dog bites anywhere. No.
We have absolutely no notice.
But the courses that reference dog bites are listed.
Say that again.
The courses that reference her teaching dog bite
Talk louder.
pattern recognition, they're listed in the resume.
All right. We'll see you at 12.
I don't like that they're going to start questioning, then do the voir dire, and then question again. I hope someone can explain to me, why not just let the jury sit out for a little bit longer and do that? I don't get that.
Sorry,
I
I
don't
thought somebody
get-
was here.
That's okay. I don't get why they want to start testimony, stop, do the voir dire, and then more testimony. Why not just
I
let the
agree.
jury have a break?
Yeah, I agree. This was her plan this morning was, all right, well, we've already had enough talk about these motions and all of this. So when we do our morning break, that's when we can do voir dire on Dr. Lapsoda. So literally it was her plan.
Yeah.
And now she's like, I don't want to do that. And I'm like,
why are they're coming back
okay.
at noon. Just let them have a longer lunch.
Yeah,
I'm sure they won't
sure they would.
complain.
Exactly. What we really think she's going to do voir dire during lunch? It's very annoying.
Yeah.
I agree, Amy Beth. It does feel like she's rushing them and being all like, well, you can't testify to this, blah, 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 blah.
Yeah. Oh,
Okay.
Beth.
But yeah, Brennan's trying to get Dr. Wolf to testify about all sorts of shit he's not qualified to talk about.
Right.
Not even close. Not even remotely close. It's very frustrating. Very frustrating. I'm certainly curious of what the jurors must be thinking today, because Brennan has been throwing his own case under the bus.
Right. He's making my head hurt today.
Right. Gosh, he's not even a textiles expert. And Brennan does this thing I notice where he'll be like, for example, he was talking about like previous studies or reports. Just name somebody, Dr. Wolf, who has done a report, right? Does he pull out a report? Nope.
Nope.
I don't even know if there are reports on that sort of BS. You know, he did a very similar thing with Dr. Russell as well about, dog bite, seminars or what they don't even exist. It doesn't
Have the
even
receipts. He's just trying to plant that
Mhm.
you didn't do your job fully kind of thing.
Yeah, it's a very interesting technique. I know why he's a defense attorney. But
He needs to
I
stick to being a
I
defense
think he's
attorney, in my
confused
opinion.
that, like, normally his job is poking holes in the state's case. But now, by poking holes in the defense's case, he's poking gigantic holes in his own case. Like, the movie Holes is Brennan's entire case.
I wonder
basically.
what's being said over on X. Lady in Gray, if you're here, let us know what people are saying over on the Twitter X world, whatever it is. Angie, I do
boy.
agree. I love Jackson's response. How about Dr. Welcher's report?
Mhm.
Do you know, Beth? Sustained.
Right? Because Dr. Wolf used Vulture's information and
Right.
all of that. So by him implying all of these problems with Dr. Wolf's math and what he used for his references was literally his own witness.
Right. Like they use 50th percentile for the head. Why can't we use 50th percentile for the arm?
Mhm.
I mean, it's like there's one set of rules for the prosecution, one set of rules for the defense. According to
and if you use a heavier arm, it's going to be worse. It's still going to be Hank Brennan apparently lies about math in open court too. I mean, I would think if he did have the 11.8 pound arm, it's going to be an even worse result.
Right.
Is my understanding. So I don't see how that helped him in any way.
I don't either. If somebody can explain to me why Hank thinks that helped him, I would love to try to understand that, because if he used a heavier one, in my thought, there would be a lot more damage, right?
Mm-hmm. That's what I would think.
Like,
That's
wouldn't
what
the
I
arm
definitely
be
think.
broken? I mean, I'm thinking broken with the bone sticking out. I'm thinking compound fracture.
Yeah. And he was all, talking about all the road rash on his sweater and everything like that. And then he brings John's shirts and he's like, what about these holes? And you're like,
Yeah.
You can't even see them. What are you even saying right now? Like, what? Why?
I would have been like, could you take that out of the glass so I can put gloves on and hold it?
Polly says they shouldn't have this many voir dires during trial at all. They should all be hashed out before. Then you wouldn't have to worry about wasting anyone's time. If something comes up, you stay later. Exactly. We all know this, that voir dire is generally always done. They qualify the experts before they're supposed to. Apparently, Burgess skipped that step all over the place. Usually, what we see is they qualify experts ahead of time. They put them through voir dire to qualify them. Sometimes, very rarely, do they do this in the middle of the trial. And that usually comes down to like an expert in like scheduling, or they might, not live close. But that's like once every 5 trials that we watch. Like it's very weird that they would do this in the middle of the defense getting ready to call this witness. Now, sometimes they will do voir dires if something is brought up in questioning that nobody was really prepared for, that person may or may not have knowledge, like that happens. But generally, that's not what happens. So, okay, where were we there? I really don't know how anyone watching can at least admit to Beth favoring the Commonwealth, especially with timing and rushing. And I even say the way she does her breaks. I agree. I finally started getting frustrated with her last week, like over the top frustrated, because I can't wait till y'all see a judge, a regular judge. Unbelievable.
Sorry, guys.
Unbelievable.
My Roomba was beeping in the background. I had to go see what Rosie's problem was.
Simone says we could get very lucky and Bev could leave the courthouse to never return there again. AWOL is still big. I mean, she's not even voted in.
Yeah. I'm like, why would she leave?
Mm-hmm.
That's funny. Candace Ivy on X. Hank Brennan doesn't understand the concept of a group project because no one ever wanted to work with him.
Oh, that's funny. That's
I
funny.
mean,
I can't wait for him now to. So in the voir dire that we have seen of the ARCA guys, right? Dr. Wolf seems very chill and whatever. Dr. Retrial also seems chill, but also like different. He has a different demeanor about him. And I'm curious to see how Brennan, I feel like he'd be the kind of person that'd be like, look at Brennan and be like, you done? Like, that's the vibe I kind of got from him. He seems like a lovely guy and all. I mean, what is Brendan gonna to say? Because so Dr. Rentschler, he will be testifying on body stuff. So, did you name her Rosie from the Jetsons?
We
Sandy
did.
Sunshine was it?
Yeah, I
Nice.
just said yes, we did.
I didn't realize that was a yes to that response.
Yes, we did. I mean, what else would you name a Roomba? Rosie.
Right? Now, you guys, when the court does go on lunch, we are going to redirect you to Terry's Midday Missing show. It's going to be a very, I already read it last night, and it's very good. So she covers missing persons cases that aren't talked about a lot, or not a lot of information's out there. You're covering Travis Decker.
Gonna give a little
what are you
update.
covering today? You tell them what your show's about.
So
Sorry.
today I am going to give a quick update on Travis Decker. We all know who he is. Then we are going to be covering the disappearance of Nancy Moore and Travis Coleman.
And they're both from Washington
They are.
as well.
And I am trying really hard to practice saying these cities. I mean, I just need towns to start doing an easier job of naming places so that I don't struggle so much. Because when you go out on the internet and you hear it pronounced 3 different ways, you're like, well, which ways do I go with?
I can't wait to hear your rants on Nancy's case.
I
was reading it last night and I was just like, oh boy, Terry is going to have so much to say, because I do as well. But no spoilers. You
I
have
have
to check it out.
so much to say.
Mhm.
And then there's some things that bother me about Travis's case. I
Mhm.
really think some laws need to change. And I think the police didn't do a great job. And you'll have to find out why, because it's frustrating.
Mhm. Yeah, missing persons
Thank
is really a big deal here on our channel.
It is. And what's so unique about that, if you're new here, I always stayed away from missing person cases because I didn't like the not knowing, the and then got into the Chase Lackey case. And now it just spawned something in me about the missing person, just to see how these families are treated. So many times they're disregarded. I mean,
Mhm.
it's almost like being a missing person. If you are not a perfect missing person, blonde hair, blue eyed, never cheated, never had a glass of wine, never did anything, you're just not going to get what you should get. I mean,
Mhm.
look at what we've seen in this case. $400,000 spent on Aperture. Do you know how much $400,000 would do to go towards a missing person? You could do a
Mhm.
lot with missing person cases. You could do a lot with untested rape kits. I mean, there's so many things, and missing persons are like the redheaded stepchildren out of
Yeah.
all types of crimes. And I don't understand it. And then if you're indigenous, Lord, you're even below second
Mhm.
class citizens.
I think a lot of people might even have like a hard time understanding like the concept of it because it's horrifying when you think about it
Mhm,
that you
mhm.
could
It
just
is.
go missing at any point in time. Like it's
It
really,
is.
I think a lot of people just also they're like, oh, if I don't think about it, then I don't have to face like
Yeah.
that could happen to me or somebody.
It's
I
it's a
know,
problem.
but
And even with cameras everywhere that we have today, we still have people that literally just disappear. And a lot of it comes down to people don't want to talk. They don't want to tell what they
Mhm.
know. They think it might be a rumor. Just like we got a tip last week in Chase's case, and she was straight up. She goes, "This could just be a rumor, but I
Mhm.
felt I should tell you because I hadn't heard you mention it at all." So it's a tip we've never gotten, a rumor I've
Mhm.
never heard. And you know what? We are so okay with that because you never know.
Mhm. Oh yeah, Amos is right too. If
Oh,
you have mental health issues, forget about it.
yeah.
Forget about it. They're not even
Mm-mm. Or if
going,
they think you're a runaway,
they're-
mental
which is
health and runaway.
crazy to me because why is it and missing? I know this isn't related to the trial, you guys, but whatever. We don't have anything really else to talk about from this morning. But why is it that we have silver alerts, right, for elderly people, or is there a different one for people with
Mhm.
disabilities, right?
Right.
A blue alert or something. But like if you have severe depression or any mental health, they're like,
Mhm.
oh no, it's fine. Like you're in danger to
Y
yourself if you
And
are
you could
having a
possibly
psychotic break.
be in danger to others too. It is also a threat to the public because if this person is in that kind of mental state, they may not be looking to just hurt themselves. They may be looking to hurt someone else,
Right, which is very, very rare. That's
which is very
very rare
rare,
for that
but
to be the case.
it's still, but
Um,
also they're more susceptible to other crimes because if someone is having a
yeah.
mental health crisis, they are easy pickings for all kind of other
Mhm.
crimes.
But
And
yeah,
like
if
Blue
that
Alert
happens, forget about it.
here in Texas is about law enforcement.
Okay.
So if a suspect did something to a police officer, there's a blue alert for that suspect for doing something to
Oh,
law
okay.
enforcement. But
Wasn't there there was a missing case I thought where the guy, kid, maybe, I don't remember, had like severe like autism.
mhm,
Um, didn't they have a special alert for people like that? Or I could just be making that up in my head and being like, oh, we should
I
have
don't
that and then don't. But okay.
I don't think so because it's still a missing and endangered
Okay.
thing.
Person. Maybe that was people being like, oh, we should have alert. Maybe that's where I'm jumbling it up in my brain. Yeah, again, the silver alerts. A lot of those people have dementia. Tell me what the
Mhm.
difference is between. That's a mental illness as well. Like I don't understand um, the difference. But good luck. Good
So
luck.
that says there is an endangered and missing persons alert, and it's called endangered and missing.
No. Okay. Well,
Okay,
I don't
that's
think.
different. But
Okay. It was that case I was thinking about, Amy.
yeah.
So,
But I mean,
okay.
I have one thing to say to Hank. Hank really needs to go back to being a defense attorney. And I think he should stick to mob type crimes, maybe.
He wasn't good at it.
I didn't say he was good at it, but maybe he should stick there because they don't have as high as expectations, maybe.
He needs to work on his, like, I don't know what his charisma or something. He
Why did
comes
they
off
pick him?
just
Why do you
not
think
great.
they picked him for special prosecutor?
I've said because he's defending the police who can be similar structures to the way mobs work is all. I mean,
Yeah, that's kind of true. And then he's, of course, is defending Jen McCabe.
well, yeah, I think that's the only reason he's there. But I'll be honest, I don't even know if I would want Brennan as my defense attorney. I mean, he's literally tanked his own case. When he does come up, he is very unlikable. Despite whatever he's trying, it's his tone and his demeanor and that weaselly arrogance and that's really important for attorney. Like, jurors will tell you the lawyer's personality, everything about them does matter. Not John O'Keefe.
What? I was going to say the screen went black for a second. You went away.
Oh,
that was a little weird.
Me too. That was weird because we're the only ones back here, and it changed like which layout we were on. I don't know what that was about. I don't know.
I thought it was me, guys. Weird. I was just sitting here going, okay, it's me. I'm having residual effects.
No, it like turned my camera and my mic off earlier saying it was unplugged, which it was not. So then I had to like leave and come back in the stream. It's very, I don't know what its deal is. And I don't even have bad weather going on. So. So it's been like that for
it went like that for a little bit. I thought it was just my other screen that went black.
No. Joe Booker had the argument completely undermines his previous argument about the weight of the arm. I know.
Okay, it says for rectangles now, but yet we're seeing us in circles.
We're rectangles?
I'm looking at my other screen. We are rectangles on my other screen, but in StreamYard, we are circles.
What is happening with StreamYard today? Gosh. Let me see what is happening.
We see circles on our end, guys.
Yeah, it's set to circles. So what's happening? Is it still that way?
Nope, we're circles now.
Okay. All right. Well, there's that. I don't like the squares because like my green screen is a circle. And so then I get these corners that that are there and you can't change the size of anything, which is annoying. Okay, well, so it's Monday. It's Monday. It's fine.
Try using the heart shape. I don't think we have heart shapes.
Do we have a heart shape?
I don't
I
think we
think
have
so.
heart shapes.
Well, no, we get like squares. Oh, the square's not too bad.
Why did it change it to yellow though?
Oh, that's just the setting on the brand. That's we just haven't set the colors up for all these different ones. And then, oh, see, there's a rectangle. You guys see it doesn't like
Yeah.
do that.
Uh-oh, Buffy says she likes the squares best.
Who likes the squares best?
Oh, Mama Llama says the squares, yes.
Oh,
Okay.
well, maybe we'll
We can try it.
try it and see, I guess.
As long as it doesn't show any more of my grays, I'm okay.
No, I see
Oh.
you. Somebody's
Like
in here
that.
helping us fix stuff.
They can see us better in squares. Maybe we don't want you
Oh,
to see
okay.
us better.
Some days, yes. By
Oh,
like
now we're back to
3 in the
circles.
afternoon. Oh, and we look like boobs.
How did we go back to circles?
Because Amos is back there trying to set things up for us to make sure everything's okay.
Oh, okay. Okay.
So it's easier to screenshot for thumbnails. Well, I think you guys have enough images of my face. Thank
Oh,
you.
no, never enough.
Oh, the chat's going to go to war over squares
know.
or circles today.
Do we need to do a poll? Are they telling us to do a poll? All I know is my eyes
Ooh.
look very tired
Oh, that's not
today.
too bad. Am I laggy? I feel like I'm laggy. Chat, am I laggy? When am I doing
That's
my
where you're
photo
going.
shoot?
Maybe in Ohio.
Oh, that's true. We'll probably take some in Ohio. That's a good idea. Are you bringing your fancy camera? Oh,
I am.
There's some like really great places to go. We can go to
I
the
may
Rose
try to
Garden.
bring the tripod. I'll
Mm.
have to see because that'll mean I have to bring my big suitcase, which I don't normally take for a 2-day trip, but I may.
Mm. Doing polls.
That'll
That's
be for the
Llama
members
after dark.
only. That'll be the members only.
All right,
from
chat's
Ohio.
spoken. Chat's spoken, and they like the squares.
As I say, I think they like the
So,
squares.
All right, squares it is.
Okay. Squares it is.
Squares it is today. We'll see. Play around with it, some other stuff. But that's what you guys want today. That's what you get because it's Monday, and we're
I'm
just
hoping
here.
today to hang up my new background.
Oh, you got a new one?
The pink one.
Oh, the pink one. Yes.
I just-
Yes, that's right.
I was going to do it this past weekend, but Bev had other ideas for me over the weekend. So,
Freaking trooper.
oh, she likes squares, but she wants us to fill the screen with them. So I think she wants the bigger squares. Buffy just wants that so she can get better screenshots of our weird looks. And now Polly says, I agree, bigger squares. Oh, that's what they like. Oh, we're really big.
We are really big, but that's okay. That's fine. Whatever makes them happy, I guess. They could be in here running the show, but that's fine.
Why is
Just
Buffy
kidding.
not on camera today?
She said she lost power earlier today.
Okay.
So
We were just told to sit down and do what she tells us.
all right.
Buffy,
Squares.
I just need
it is.
to tell you something. The more people tell me what to do, the more I do the opposite. I don't like to be told what to do. Just ask Double H. It's taken him 22 years to learn, but he has figured that out. If he wants me to do something, tell me the opposite. Like he'll say, Terry, I don't think you should have a glass of wine tonight. Seriously? Straight to the kitchen I go.
I think that's called
Reverse psychology.
oppositional defiance disorder, but sure. I'm just kidding.
Reverse psychology.
Oh, Court's back. Let's see. Oh, there we go. Do you squares for this
All right,
too?
so I'm told council wanted to see me.
Your Honor, issues has arisen related to
I don't know if they can.
cross-examination, re-cross-examination of the last witness, and Mr. Alessi would like to address the board in detail about that.
All right, so the last witness was your witness? Is there a reason?
This is a separate issue, and I'm asking Mr. Alessi to address the board on this.
Okay. What do you want to tell me, Mr.
Yes,
Leslie?
yes.
Bear with me a moment, Your Honor. I need to put on evidence gloves.
Come on, Alyssa.
Evidence gloves.
Ooh, he's getting gloves on. So you're gonna
I'm gonna
give
go running for my
Hank
coffee real quick.
a prostate exam? Okay, Alyssa, do you not know how to do this better? If you lean over and blow into it, they'll slide on a little easier. Good morning, Kelly B.
Why if I stop my cam, it's taking.
Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the hoodie. In this regards questioning and representations and questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is to have 2 documents marked as exhibits. And then I am going to use exhibit 88, which is an evidence, which is the hoodie, which is why I'm putting on the evidence gloves. And it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
Terry, can you try to bring up a comment?
What I would like to have marked.
So did it make the trial go away from you too? All right,
Yes.
sorry guys, we're not
What I
going
would
to
like to have
comments
marked, the
until
first document.
we can. You can come back, which is not now.
The specific title. These 2 documents are from the criminalist's file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the hoodie sweatshirt that's in the crime lab file folder.
Okay.
So the first
No, you can't.
is
Don't put any comments up.
the back of the hoodie. So with Your Honor's permission, I would have that marked for identification.
Exhibit YYY. Friday.
And may I see that, please? Okay.
That is the back of the hoodie, Your Honor. And if I could please have the next marked in order exhibit for identification.
Exhibit ZZZ, Friday identification.
Just give me a minute to read this, Mr. Leslie.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes in the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay. I can't tell entirely from ZZZ, but if that's your argument, why, for identification appears to support that.
Your Honor, may I have the exhibits marked for identification back for my argument?
Okay.
Thank you, Your Honor. Thank you, Madam Court Reporter. Your Honor, what we just saw is Attorney Brennan question Dr. Wolf with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is the, what happened was Attorney Brennan held up the casing with a hoodie sweatshirt, went to the back of the hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor. The
Okay.
first time I realized
That's what happens when you
Okay.
assume, Bev.
the absence of this pretty important piece.
Okay. Go ahead, Mr. Lessie.
Thank you, Your Honor. So to do it in order, Mr. Brennan takes the hoodie sweatshirt in the casing without notice, shows it to Dr. Wolf, and shows the back of the, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now? It would help me if you held it up for me now,
Absolutely, Your
Mr.
Honor.
Lessie.
They took it out of the
So-
plastic?
Here is the back
Okay.
of the hoodie.
All right, thank you.
What?
It's very obvious that these are cutting holes.
Guys, let's give this 1 second. I'm going to go out and come back in and see if this solves the stream problem, because now it's just going without us pressing anything. I have a pause. Not going to miss anything. Give me like 1 minute. Okay. We'll see if that works.
Technical difficulties. Well, while we wait for Llama to come back, this I did not see coming. I would love to see if anybody in the chat saw this coming.
All right. Let's see if this works. So sorry. I don't know what's going on with StreamYard. Okay. Now it's letting me put comments up and
Okay.
the video. Okay. So we just need a quick restart. Okay. Back to this.
Cut by the criminalist. And I'm going to get to back to this in a moment. But I would like to do it and certainly entertain any of your Honor's questions, but in a logical order.
Sure. So I'm not, what about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your Honor.
Okay. All right. Thank you. Go ahead, Mr. Leslie.
Thank you, Your Honor. So I just want to get the flow back going here in the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up. We have no idea that this was going to happen. Goes up, confronts the witness, Dr. Wolf, shows the back of the hoodie sweatshirt. To my knowledge, the first time the back has been referenced of the hoodie sweatshirt. Shows Dr. Wolf, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolf is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29th, 2022.
So do you have something you said, when you said obviously cut by the criminalist, do you have something that shows that chart that I couldn't understand quickly? Is it on that? Does
Yes,
that do
Your
the
Honor.
back?
What
Okay.
we have is two documents to show that.
Right. So the second one, when was that provided?
These, when you say provided, you mean with regard to when did the defense get these in
Yes.
a discovery? Let me get the date, Your Honor.
Sure.
I don't think Bev saw this coming either.
Notice of discovery, May 2023.
Okay, thank you.
And I will note, exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie, I believe is the only one, to my knowledge, not put into evidence, not turned into evidence. This is the one that it clearly shows the hoodie before the criminalist started her work with the cuts. There are no cuts to YYY, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right. So is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolf. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top. LIMS 22-218-4, analyst MSH, which is the initials for Ms. Hartnett. Dates: May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the...
You know what? Can you bring it up to me, please?
I certainly can, Your Honor. And I can conduct my argument from right here if that helps, Your Honor.
I just want to point out to me where it says, where it shows the back.
This is not great, you guys. Well, I mean, it's great if it's granted, but like,
then you can see the very
yikes.
Do you think Hank, I'm taking notes over here. Do you think Hank did this on purpose, or
let me just get it.
did he make a
I
mistake?
thought you were writing, Terry loves the Lessie with a heart around it. I thought that's what you were doing.
Thank you.
And I'm
So Mr. Leslie, stay here.
yes.
Leslie, you just stay right here. Oh, Hank, why don't you come up here too? I need them to talk louder.
Can I get the objective?
Labeled cuttings.
Pardon me?
The labeled cuttings.
Right, but if I can, Your Honor, I want to clarify this. Yes, are you willing just one? Let me just make sure I get.
Mr. Jackson, it says exterior front, what Mr. Leslie was pointing me to.
Well, just a second. We may print the wrong page. I can do it, but Mr. Wolf, can you print the back? And Your Honor, are you comfortable using the computer or the back? Because I think we just had the wrong one.
We need to mark it though.
I understood. We will. He's printing it right now.
How's Bev not sitting there going, oh shit, this is a problem?
Right, the littlest mom. He's like, damn.
Look at Karen. She's all. I bet you know she knows this case inside and
We
out.
wanted to have the front
Of course.
and the back to show all the cuttings, but would only print it out was the front. We are now printing the back. Your Honor is correct.
That's what I think. Dope meditation. And that's why I asked. I wrote that down. I think he just screwed up.
Mm-hmm. He's going to call us an ambush somehow.
Okay.
Well, Your Honor, because of the thousands and thousands of terabytes of data we have, how was I supposed to know? I haven't had time to prepare. This is an ambush.
She calls us a mistrial. We're going to have to pop some champagne.
She does not look happy right now.
She does not. She's turning red. Look at her.
Mm-hmm.
She might be put in a situation that she has to go against what she really wants to do.
I mean, most likely she'll probably deny it, but you never know.
I don't know, because
How was it not in evidence? That's wild to me, because they had that woman testify, but I don't know. Okay.
If I may, Your Honor, I'm advised it will take 2 minutes because it has to go.
All right, so go ahead with your argument.
Thank you, Your Honor. So, Your Honor, what is being printed is which we will mark, will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than the
So
criminals.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And here is the reason for the motion for a mistrial with prejudice. On its own, to do this, and you put together all of the parts of what just occurred. You start with the fact that and if I could, Your Honor, now that I have it yet marked so I can then refer to it.
All right.
Thank you.
Can you print extra copies too, so I can have my own copy?
Absolutely.
And for the Commonwealth to see.
And I'm going to show the Commonwealth what I just printed.
Exhibit A.
I like how he still has the gloves on. I do hope that he doesn't go and touch the sweater. He kind of already touched it when he had already touched the podium and everything, but
Brennan's looking at it like, oh boy.
his glasses on.
Yeah. I think Bev is a little more interested in this request than the last one.
I agree.
She looked a little upset. I agree, Dope. She looks.
She's going to tell, we'll take a break and I'll come back with my decision after lunch.
I don't think she's going to do it. I mean, I said he was
Mr. Brenner's reviewing that. We may
going
head
to
to
give a rectal exam, and he's given Brennan a good one with
the
this.
chain of custody document for these, and that's that he marked is the next exhibit in order.
Okay.
And then with Your Honor's permission, I would have Madam Court Reporter hand them both up to Your Honor so
Sure.
Your Honor can see what I'm referencing.
Thank you.
Exhibit B for ID.
Thank you.
It's okay, RTC.
Here it is. Thank you, Madam Court Reporter.
Do you need this, Mr. Leslie?
I do not need either of them, Your Honor, and I have the extra copies as well. Okay, so Your Honor, I now have enough copies for Your Honor and for the Commonwealth.
Oh, thank you.
I mean, if they really wanted to save face, throw Brennan under the bus, you know?
Yeah, thank you.
I still do not have ZZ's.
All right. Thank you. Okay, go ahead, Mr. Lessie.
So, Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist, Ms. Hartnett, with the back of the hoodie with no holes on it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document that describes the chain of custody for the hoodie and the cuts in the chronology. And of course, we have exhibit 88, which is the hoodie. So what Mr. Brennan did, and I'm now pulling exhibit 88, he holds up the back of the hoodie, which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case, Ms. Hartnett, she's testified.
You didn't change your gloves.
And Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes in the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolf, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminal list, that those holes in the back were caused by their criminalist as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision that never occurred? That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is on the key issue of this case, whether there was any collision at all. On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that what just happened, and I'm not going to repeat or go into other than to reference. This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right. So let's move along from
right,
that.
That's what, and I'm going to come back to this. Why is this occurring, Your Honor? Why is this happening?
I'm with you, bro.
The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolf, the ARCA expert, to try to make it seem like Dr. Wolf didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolf on were caused by the Commonwealth's own criminalists as part of sampling. I don't believe one could come up with more misleading, misdirecting elucidation of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one, and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits
Only on the
the
back.
sanction of a mistrial with prejudice. The amount of effort, the amount of work, I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense. That should befall the prosecution. Ms. Reed, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard, to do justice, to create a fair trial. This is the antithesis of a fair trial. Ms. Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear the more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
All right, thank you. Mr. Brennan.
What you got, Brennan? Come on. Do the crawfish crawl. Come on. Do the crawfish crawl.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake.
Oh,
And
Say
so I
about
think
it,
what
the
should
people in the
happen
back.
is there should be a curative instruction. There should be a stipulation.
Oh,
The court
Jesus.
should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt.
can't
And
undo
the
that.
court should allow the defense to introduce the lab paperwork.
Mm,
Wow.
he admitted it.
I'm not going to allow the mistrial motion.
Shocker.
Of course you're
Alessi.
not.
What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B. 4 of each letters. I'm going to put all these into evidence. They can be displayed for the jury, and I'm going to instruct the jury that during the cross-examination of Dr. Wolf, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they
Bullshit.
perhaps could have come from events or
No.
implying or something like this.
No. Brennan should have to
I
say I
instruct you,
screwed
you
up.
are not permitted to draw any inference that these could have come from the events of January 29th, 2022. I instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can I see those, please? It's unclear for me. Do you have a better idea, Mr. Alessi, what day
You got a better
these were
idea for a
done?
mistrial.
Was it
That's
all
what I
of
got an
those
idea
3
for.
days? Now I see a 4th day. 5/11, no, I'm sorry, 5/11, 5/12, 5/11, 2022, 5/12, 2023, and 6/18, 2023. Those are the 3 dates.
Your Honor, on about May 18th, when the defense filed a motion to test. So that's the probative date.
So May 18th?
Yes, that's good.
Okay.
And that's 2023.
Yep. All right. That's what I'm going to do. Is there anything
Yeah.
further you want me to include in the instruction? Your rights are saved regarding the mistrial. I disagree with you on that.
Your Honor,
Of
I'm not
course you
gonna go
would.
any more into the argument, but I appreciate the opportunity to provide perhaps some further instruction for Your Honor.
I hope
So
they're
I'll
watching.
hear you. Go ahead.
So the first, Your Honor, is with regard to 2 things. One, I would like the opportunity to have the hoodie sweatshirt held up. Because that's what
Okay.
happened.
Yes. Yes.
These holes in the
Yes.
back.
Yes.
Thank you. So that's number one as part of the stipulation. And then
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a stipulation. It's from me, which I think is more forceful.
I misspoke, Your Honor. I agree, not a stipulation, but just as Your Honor said, with regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview. Your Honor said that rock wasn't present, on or about the time of event.
So I do say that when I say Ms. Harnett did this. So rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes were a result of the events on January 29th, So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in.
Wow.
It's what I said, Mr. Alessi.
Your Honor, I was consulting with Mr. Alessi. I'm not showing disrespect to the court.
Okay.
Of course, you were listening.
All right, so it's what I said,
What a
Mr. Alessi.
bitch.
I instruct you that you're not permitted to draw an inference that the
An
holes
inference.
came from the events of January 29, 2025. Those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor, last comment, to instead of not drawing inference, you should conclude that these holes were not present in the hoodie sweatshirt. They were caused by the criminalist.
So I can just leave that all out then and just say, Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18th. It's
And Mr.
probably
Brennan
neater that
knew
way
that.
anyway. All right, let's bring him in, please.
And tried to set it up. Oh, that's
Just as a
BS.
housekeeping matter, the sweatshirt's been taken out of the plastic sheet, and it might need to be remarked. The plastic sheeting was marked, but if we're going to put it into a bag or something like that, we might need to have it marked. But we don't need to do that right this second.
I am so
Yes.
salty with her right now.
I mean, she's trying to act like it's not. Oh, it just is a thing. It's fine. He basically lied and tried to set up.
All right, thank you. I'm sorry.
Mm. Mm.
I want to know what the jury thinks after this
Mr.
is
Leslie,
all
you're
over and
simply
they
going
go
to
back
stand
and
and hold
find
the
this out.
sweatshirt, right?
Yes, Your Honor.
Okay.
So this is exhibit 223.
And Your Honor, I would hold it as Your Honor begins to read. Is that consistent with Your Honor's expectation?
No, I want you to hold it up with the back.
What would you like me to start with?
You do that first, and then I'll give the instruction.
Thank you, Your Honor.
Wow.
All right, so Mr. Leslie, why don't you just, where are you going to stand?
Pardon me?
Where are you going to stand?
I would suggest, Your Honor, right about here.
All right? So you can stand there, you can hold it up, then I'm going to ask you to put it down, and then I'll give the instruction.
And then I will return it to Mr. McDermott with the court officer.
Yes,
Thank
court officer.
you. Bear with me a moment, Your Honor. I'm going to put on the.
All right, then we will take the luncheon recess. When we come back, we'll have the voir dire. Or actually, is Dr. Lapisada here?
She's here, but she's not next. I'm gonna call
John Tiedemann.
For just the measurements?
Go ahead.
Wow.
Your Honor, am I going to be able to show the exhibits from Ms. Hartnett or the cuts along with the next step of the show the cuts were made by Ms. Hartnett?
Well, I say it, and I'm going to tell her what they are, so.
Boy.
I honestly didn't think she could make me more mad. I really thought she had pushed me to my limit.
I mean, she doesn't be rude about it.
I know
I don't
she's just
think
being a
Alessia was
flat
being
out.
rude.
See you
She's
next
doing
time.
a freaking job. Oh, yes, appeals will be brought. I mean,
But we know
Please be seated. Court is in session.
All right.
I was the
Jurors, I
jury. I would be pissed.
appreciate your patience. Mr. Leslie, why don't you hold the exhibit up for the jurors, please?
And let me fix Hanky's mistake.
I like that Alessia is the one doing
All
it
right, jurors,
too.
that's the back of the sweatshirt that was shown to Dr. Wolf.
Yes.
Okay. Thank you. Why don't you go ahead and put it back in the bag? So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know your lunches are here, but
That's
I think
it?
we'll, Mr. Yannetti, your next witness, please.
John Tiedemann.
In September, are you doing grand jury, Joe? if anything, a grand jury might be a good spot. You can make sure people are actually charged if there's evidence. Just saying.
I think her response to that was very not good enough.
Mhm.
All right, good afternoon. Go ahead, Mr. Yannetti, whenever you're ready.
Thank you. Good afternoon, sir. In a good loud voice, would you please state your name and spell your last name?
Sure. My name is John Tedeman. It's Tedeman.
Do you work, sir?
I do.
What do you do for work?
I am a private investigator.
Do you work for someone else or do you have your own firm?
I have my own firm.
What is the name?
Forum Investigations.
And that's Forum?
Correct.
I'd like to ask you a little bit about your education and work history. You're from this area?
Yes, Boston proper.
I'm sorry?
Yes, from Boston.
Where did you attend high school?
The Roxbury Latin School.
When did you graduate?
1996.
Where did you go to college?
I went to Princeton University.
What year did you graduate?
2000.
What did you do after graduation from Princeton University?
I became a federal agent.
Where?
The agency or the location?
Oh, I meant the location. Sorry.
I started out in Los Angeles and then I was back in Boston.
And what years were you a federal agent in Boston and Los Angeles?
2002 through 2008.
And what agency did you work for?
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations, all sorts of things, anything involving a Social Security number, basically.
And why did you leave in 2008?
I went to law school.
Where?
Suffolk.
What year did you graduate from Suffolk Law School?
2013.
And what did you do after graduation from Suffolk Law School?
I've had a small solo law practice and worked as a real estate broker.
And what type of law did you practice?
Mostly real estate law.
When did you start Forum Investigations?
In April of 2024.
Are you still practicing as a lawyer?
Not very much, no. I still have my license, but my bar card, but I don't practice much.
All right. How did you become involved in this case?
I was contacted by somebody from your office last Tuesday, I believe, the 3rd.
Okay. And was it explained to you why you were brought in at this late juncture?
Yes, it was explained that there was another investigator who had a health issue and would not be able to testify. So would I be able to help out with a small assignment?
And what were you asked to do?
I was asked to travel to 34 Fairview Road in Canton and take some measurements and photographs.
Did you agree to do that?
Yes.
When did you go?
On June 3rd. I believe I arrived about 5:30 at 34 Fairview.
Okay. And when you say June 3rd, we are talking about last week.
Yes,
correct?
last week. Yes.
Whom did you see when you got there?
One of the homeowners, an older gentleman, greeted me when I pulled in the driveway.
All right. And it was not the Albert family, correct?
It was not.
Did that individual give you permission to enter onto the property?
He did.
What did you bring with you?
I brought an iPhone as a camera, and I brought a wheeled measuring device.
All right, can you describe what a wheeled measuring device is?
Yeah, it's like a handle with 2 wheels at the bottom, and in the middle there's like a little odometer that measures feet and inches.
And if we could, Mr. Wolk, could we display the photo of the front of 34 Fairview that's already in evidence with the court's permission?
Yes.
And what exhibit number is that, Mr. Wolk? 46. Do you see exhibit 46 on the screen, sir?
I do.
Do you recognize that?
I do.
What do you recognize that to be?
That is 34 Fairview Road in Canton.
When you got to 34 Fairview Road in Canton on June 3rd, did you make note of the various entrances to the residence on the front, from the front of the house?
I did.
Could you describe those for the jury?
Yes, on the left side center of the building, there's what I would call the front door, up those 4 steps, I guess. Then if you were to look farther to the right, there at the end of the main building, there's another door, which I guess is the second front door or side door.
And with regard to that door, is it fair to say that faces outward, faces toward the road?
It does. It faces directly towards the road.
Okay, continue, please.
And then past that to the right, there are the windows. And then if you can see the little red line, that is a side door that goes into the garage. Yes, right there.
It's been highlighted there?
Yes.
Okay. And then there are obviously the two garage doors.
The two garage car doors, yes.
4 cars to enter. Okay.
Yes.
We can take that down. Mr. Wilk, and put the lights on. May I approach the witness, Your Honor?
Yes.
So I've placed a photograph in front of you. Can you identify that for the jury?
Yes, that appears to be a photograph that I took of the side front door, the secondary front door, the garage door, and the two car doors to the garage.
Okay, particularly with regard to the side pedestrian entrance into the garage, the red door that you identified in the previous exhibit. Does that photograph fairly and accurately represent the layout of the house in terms of the outside and the entrances that you've previously testified to?
Yes, it does.
I would offer that, Your Honor.
All right, can I see those, please, sir?
Now I have a question, and I don't think a lot of people are going to like this question, but so there's 3 doors in the front of the Alberts home.
Mhm.
From my understanding, John has never been to the Alberts home. How would he know which is the right door to go in and just walk into in a house he's never been to? It's kind of weird.
I hadn't thought of that.
Just wondering.
I'm still so frustrated with Bev.
Oh, I'm frustrated too, for sure. I'm just trying not to think about her right now.
She did not do justice to Karen Reed by what she just gave to the jury.
I was going to say her instructions to the jury just really don't. It's the same with The Rock when they had The Rock at the jury when the jury went and saw it, and she was just like, just ignore that. What?
If I was the
I
jury,
do feel like that should have been a mistrial right then and there.
right?
It looked
And
like
I
there was
find this
blood
out
on The Rock.
later. Can you imagine what you would feel seeing that this was kept from you and that's all you got? She tried to make it little bitty when it was a big deal, in my opinion, but I'm not an attorney.
Haley says, according to Karen Reed, when they pulled up outside the house seemed to be in darkness. I reckon John entered the house from the back and met with the dog. I don't know if I'd go knocking on any back doors that time of night. Especially, I don't know. I don't know about that. Maybe one of the doors is open. But it was, we hear it's dark and then we hear, the McCabe's are peeping out the windows. Maybe they saw him and waved him on. I don't know. Problem is we don't have the full stories from these people, so, because Jen and them can't be like, oh yeah, we're standing at the door and waving him in, because that's what I would think, right? He's never been to this house before. Everybody's blowing up his phone. I would imagine that, yes, somebody was at one of those doors waving them in, or they had, even though it was cold as crap out because you had so many people in the house, you'd probably leave the main door open and just leave like the glass one.
The glass one.
So that way people know that's the door. That is what happened. But with the story we've been presented, apparently it was dark. Nobody was waving him in. They were looking at the window, but not at that time, of course. So I just wonder. I mean, I would think.
Peggy looks defeated. Look at her.
Mm-hmm.
She looks defeated.
There are technically 2 front doors, and there's also the side door to the garage that can't, right. That red one. Open the screen, but to which door? The side one, right?
No.
Karen says he went in, not the main door, but
The other door.
that one, right? Okay.
Elbow feet. You're going to want to go back and catch up on those 10 minutes.
I mean, I feel like, yes, somebody would have been at the door or the door would have been left open. So people knew the right one to go in. Like, that's just how we do things.
That's how we do them here.
Yeah. But according to everybody else, that's not what happened. So, and especially since they're all drinking, like, yeah, that front door's going to be open. Because they're all going to be hot. Like, that's a lot of people. You've all been drinking. There's a lot in the house. You're going to leave the door open. Oh, okay. Thank you, Simone. Yes, I do like her outfit. I think she just wanted to feel like she might be, you know,
Okay, Mr. Wolk, whenever you're ready.
wanted by somebody else. And that was all. I don't think it was about him. He was a means to an end, if you will. It's the door on the left. Okay. It's the main door. Okay.
Do you see what has been?
So I'm going to ask you to take that down. Folks, we're going to take the luncheon break at this point, okay?
Hi.
For the jury, right this way, please.
What the?
I am so over her.
Maybe she needs to go eat because she is hangry. She needs to do something.
Let's see. Door they don't use to enter and exit the house could remain locked. We had something similar. Sure. Yeah. You always put the house in dark mode when expecting visitors. Well, I don't know.
She looks so annoyed.
All right, so we'll fix that during the luncheon break, Ms. Gianetti, to what I said. All right, so can we get Dr. Lapasada in here? We'll do a very brief voir dire of her.
Okay, so
Do y'all think her husband tells her each night, lady, you're screwing up? Or do you think he just keeps his mouth shut?
I think he keeps his mouth shut. I would. All right. O-S-A-T-A. I wonder what her husband does.
Then you're going to step up, face the clerk, and raise your right hand.
Do solemnly swear the evidence you give to the court in case you have evidence the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. Good afternoon, doctor.
Good afternoon, Your Honor.
We're going to do a brief voir dire, okay?
No problem.
Thank you. All right, Mr. Jackson, foundation on just those 2 points, please. Sure.
Oh, jeez. Oh, I didn't do that right. That's got me all sorts of frazzled now over here.
Yeah.
Your Honor, for purposes of expediting, does the court wish for me to go through the foundation of the doctor's education, training, and background and experience, which is going to take a minute?
Yeah, no, just focus on the foundation for the dog bites and focus on the foundation for what's been termed to be perhaps biomechanical engineering evidence, those 2 areas. And if there is support or methodology in Dr. Lapasada's resume to point to exactly where that is, okay? And I expect this whole voir dire should take no more than 15 minutes.
I'll do my best, Your Honor. Doctor, could you please state your name for the record? Spell your last name into the record, please.
Yes, Dr. Elizabeth Lapasada. That's spelled Laposata.
Dr. Lapasada, what do you do for a living?
I'm a medical doctor subspecializing in forensic pathology.
Dr. Lapasada, I'm going to move very, very quickly past the bulk of your training and experience over decades. I'm going to ask you a couple of quick questions. Where did you get your medical degree?
University of Maryland School of Medicine.
And do you have any subordinate degrees to your medical degree?
Yes, I have board certifications in anatomic and forensic pathology.
How long have you had those board certifications?
Like 35, 40 years.
Have you ever worked as a medical examiner in any capacity?
Yes, I have.
Have you ever worked as a chief medical examiner for any agency or governmental agency or state?
Yes, I have.
Describe that for the court, please.
I was a chief medical examiner for the state of Rhode Island for 12 years.
How many autopsies would you say in general that you have conducted yourself?
Over 3,000.
How many autopsies in your experience as a supervisor in one capacity or another would you say you've supervised over your tenure?
Over 7,000.
Of those 7,000 that you have supervised, have any of those dealt with motor vehicle incidents?
Many.
Have any of those dealt with motor vehicle and pedestrian incidents?
Many.
Give me an idea, if you have a number in mind, how many motor vehicle pedestrian autopsies you have been involved with, either directly or from a supervisory standpoint.
Hundreds, over 500 at least.
Do you have a significant background and training in the cause and manner of death?
Yes, I do.
Is that the main goal or the main job or duty performed by a medical examiner?
Yes, it is.
Is it also significant in terms of supervising other subordinate medical examiners who may work under your charge?
Yes, you have to make sure they're doing it right.
Is there a methodology that you have employed and that is standard in the industry to employ, including differential diagnoses and inferential thinking in terms of coming to conclusions related to manner and cause of death?
Yes.
Can you explain that for the court in brief, please? I know you probably have a very lengthy explanation. Okay. Do it as briefly as you can, with being as succinct as you can.
Certainly. To determine cause of manner and death, we look at scene investigation, autopsy findings, police and witness statements, and medical history. And using that information, we come up with a differential diagnosis or a list of things that might have happened to that person to cause them to die. And from that list, then we see where all the science and all the data, which one it supports. So we've looked at several different things. I always told my staff, I said, how can we be wrong what else could this be? So you have to make what in medicine is called a differential diagnosis and then see what the facts support.
Did you employ a differential diagnosis in this case?
Yes, I did.
Do you have to be at the scene in order to understand or analyze information that you get in a police report or photographs or things of that nature?
No, that we use the police investigation and scene investigation, crime lab reports, photographs taken by the crime lab, by the police at the scene.
Have you qualified as a expert forensic and anatomical pathologist in other courts in Massachusetts and other states?
Yes, I have.
Approximately how many times would you say you've qualified?
Hundreds.
I want to talk for a specific for a second about a specific area of interest for the court. Were you provided information and photographs of John O'Keefe's arm and his arm injuries included with the rest of the autopsy information that you received?
Yes.
Were you asked to make a determination about the nature of the wounds specific to his right arm? I know that there's other injuries to Mr. O'Keefe, but I'd like to relegate your attention to the right arm.
Yes, absolutely. That's what the forensic pathologist does.
Without telling me what your opinion was, were you able to come to an opinion or conclusion about the source of those injuries?
Yes, I was.
What methodology did you employ to come to that opinion or conclusion, or those opinions and conclusions?
My experience and knowledge and training, along with the appearance of the wounds on the right arm, which fit a pattern, and then knowing that it fits a pattern, then I can try to look for, okay, what is the item that caused this pattern? And that would be part of the differential diagnosis that I've used for many, many years in making diagnoses and determinations.
Have you ever been trained in pattern recognition?
Yes.
In what capacity?
Oh, as a forensic pathologist and medical examiner, a large amount of our work has to do with recognizing pattern injuries, because that's so important, because it gives us an idea of what might have caused that injury. And then that's clearly of a lot of importance to the police and the investigators as they're trying then to say, well, what could have caused that injury? And so the forensic pathologist could say, well, I think it was X or Y. Then they can carry out their investigation armed with that information as to what might have caused the injury on the body.
Is there such a thing in the world of pathologists as medical literature or academic literature that deals with pattern recognition?
Yes.
Are you familiar with some or most of those publications?
Absolutely.
Have you ever yourself taught classes on pattern recognition?
Yes.
At what level? High school, graduate school,
At the
medical school?
medical school level.
How often have you taught courses on pattern recognition?
Oh, at least a handful.
When was the last time you taught a course in pattern recognition?
Let's see, last month.
Do any of the courses that you've either taken, well, let's take them one at a time. Have any of the courses that you've ever taken dealt with wound pattern recognition as it relates to animal wounds?
Courses that I've taken?
That you have taken?
It's part of our basic training and understanding of a forensic pathologist. The board exams we take test for that. Those injuries are described in our basic forensic pathology and medicine textbooks. They appear continually in our medical and scientific journals.
Is that an important skill set to develop, wound pattern recognition as it pertains to animals as a forensic pathologist?
Absolutely.
Do any of those academic courses that you've either taken or reference works that you just referred to, do any of those deal with dog bites and claw marks specifically?
Oh, yes, they do.
In the course or courses that you have taught related to wound pattern recognition, have you ever taught on the subject of dog bite wounds and the recognition of dog bite wounds?
Yes, I have.
When was the last time you did that?
Let's see, it would be in the course in the medical school. Would have been several years ago.
Doctor, with regard to staying with dog bite wounds specifically, have you ever performed an autopsy that specifically dealt with dog bite wounds, known dog bite wounds?
Yes.
So you've seen them in person?
Yes, I have.
Have you ever been qualified in any court in the land, state or federal court, on the issue of wound pattern recognition as it pertains to dog bites?
Yes.
When was that?
The last one I can recall was a federal case involving questions of a police dog.
Did you engage, in that case, did you engage in a differential diagnosis to determine, in your opinion and conclusion, your expert opinion and conclusion, the source of the wounds that you saw?
Yes.
Did the court qualify you to speak on that issue in court?
Yes,
Did you in fact testify in furtherance of your opinions and conclusions in that case?
I did.
I want to turn for a second to motor vehicle accidents or motor vehicle incidents. Do you also, some of the same questions, have you also performed autopsies on known motor vehicle pedestrian incidents?
Yes,
How many times would you say you've performed an autopsy on those issues?
hundreds, maybe even 1,000.
Is that a relatively common occurrence, as sad as it may be, motor vehicle pedestrian incidents in the field of forensic pathology?
Yes, it is, unfortunately.
Have you performed autopsies personally as well as supervised autopsies on motor vehicle pedestrian incidents?
Yes.
And what methodology do you employ in furtherance of coming to opinions and conclusions regarding cause and manner of death specific to motor vehicle pedestrian incidents?
Well, we look at the scene investigation. We look at what the motor vehicle looked like. We look at hospital records, the autopsy, and then trying to understand how the injuries that the pedestrian sustained, what those mechanisms were, and how the injuries show that that person interacted with the motor vehicle.
In doing so, in coming up with injury mechanism analysis, is it important to look at and analyze the actual vehicle that is allegedly involved?
Yes, you want to look at photographs of that or see it in person.
Is that part of the normal methodology that is employed in the field?
Yes, you must look at the photographs. You must see what the vehicle looks like.
Do you also look at the other side of that handshake? In other words, look at the body of the individual that was, in your case, killed, the decedent, in order to marry the two and determine whether or not the cause and manner of death had something to do with the motor vehicle, a motor vehicle impact?
Absolutely.
Describe that for us, please. What are some of the things that you look for that's part of the normal methodology that a forensic pathologist employs?
Well, when we examine a fatality from a motor vehicle, we want to try to understand what led up to it, how the impact occurred, and then what happened after. So we would study information about the injuries to see if we can relate them to certain pattern injuries that would be on the car. There are also evidence of transfer of energy and injuries that can result from the transfer of energy. So using the body, looking at the scene and the vehicle, understanding the motions of the vehicle and how they would have produced or would not have produced certain injuries on the body.
I'm going to take them one at a time. With regard to animal wounds or dog bites, were you able, in this case, using differential diagnoses, using inferential thinking, and using the skills that you've developed over decades of your education, training, and background, were you able to, without telling me what the conclusion is, were you able to come to a conclusion or opinion as to whether or not the wounds that you saw on John O'Keefe's right arm were consistent or inconsistent with a dog bite or claw marks?
I was able to come to a definite scientific conclusion.
And is that conclusion to a reasonable degree of medical certainty?
Yes.
Is it to a reasonable degree of scientific certainty?
Yes, it is.
Is it consistent with the training and methodology that you've employed over decades?
It is.
I'm going to ask you the same series of questions with regard to the motor vehicle incident. Did you review the autopsy report in an effort to look at John O'Keefe's entire body and all of the injuries that he sustained, not simply his right arm?
I looked at everything.
In doing so, were you able to come to an opinion or a conclusion as to the mechanism of injury and whether or not his injuries in total were consistent or inconsistent with a motor vehicle incident or impact?
I was able to come to a scientific conclusion.
And without telling me what that scientific conclusion is at this point, did you employ the same methodology that you've explained to the court earlier concerning differential diagnoses, inferential thinking, and decades of training, the education, training, and background that you've described for the court in coming to your conclusions about whether or not the cause and manner of death was consistent or inconsistent with a motor vehicle impact?
Yes.
Your Honor, is there any area that I have not covered to the court's satisfaction?
So I'll let Mr. Brennan ask questions. I may have a couple of questions.
What for? Why are we even doing this? I don't see how she's not
Good
qualified.
afternoon, Dr. La Posada.
Good afternoon.
If we could start with dog bites.
Do
Yes.
you know what a
Do you have
dog
any
is?
specific training in wound pattern recognition regarding dog bites?
Yes, it's in our literature standard textbook. It's standard information that is needed to be a forensic pathologist.
When did you receive training regarding pattern recognition of dog bites?
Beginning when I took my board, started in 1983.
And what did that entail?
It entailed reading literature. It entailed reading the standard forensic pathology and medicine textbooks. And it is a sub-part of understanding pattern injuries. Dog bite injuries are described in all our journals and all our standard forensic textbooks.
Other than reading about it when you were studying for your boards, did you have any practical experience where you were engaging in the field in pattern recognition analysis regarding dog bites?
Yes, yes.
And
I've had many cases where there have been dog bite injuries.
When you were studying for your boards, were you doing that, or after you
Well,
completed your boards?
I'm telling you that that it's such a basic part that during studying for boards, it's a section that we study. And I, of course, had many cases since then.
Did you receive any education past reading literature for the boards, where you took classes, seminars, where it taught specifically wound pattern recognition regarding dog bites?
It's all part of wound pattern recognition. It's usually included in literature. If there are lectures about patterned injuries, it's a subset of pattern injuries like hammer injuries, like gunshot wounds, like baseball bat injuries. There's a huge number of types of patterned injuries that are part and parcel of what a medical examiner has to understand and diagnose.
Do you remember taking any specific classes or any specific training about wound pattern recognition relative to specifically dog bites?
Yes, it's in all the literature that I keep up with.
Did you take any training or did you attend any classes
I do not agree.
that involved wound pattern recognition of dog bites?
Yes, it's often included in our seminars and case reports.
Do you list any of those classes or seminars on your resume?
That I took? No.
Can you identify one of those classes, where it was, when it was, who taught it, what the name of it was regarding wound pattern recognition relative to dog bites?
I can't give you a specific time and date.
Can you remember the name of the last class or seminar that you took or completed that has to do with wound pattern recognition relative to dog bites?
I can't recall.
Is there anything in your report that identifies any of your specific education or training on wound pattern recognition as it relates to dog bites?
It's in my CV. It's basic knowledge that a forensic pathologist has to have.
I will ask you about the CV, but Dr. Lapasada, I just wanted to ask you about your report first. Is there anything in your report that points to any specific training
In the report that I wrote on
in your
this
report
case,
relative to wound pattern recognition as to dog bites? Is there anything in your report that identifies that for us?
in my report, I put together the case of what happened to Mr. O'Keefe.
Okay. As far as your experience, though, do you ever make any note in your report about your specific experience and training about wound pattern recognition for dog bites in your report?
No, it's not appropriate.
In your CV, is there any way you can point to us where you had specific training for wound pattern recognition relative to dog bites, where we can see that on your CV?
No, it doesn't say dog bite training specifically, no.
Do you have anything on your CV that specifically talks about wound pattern recognition for animals?
Those are usually classified within other pattern recognition.
Do you have anything specific that would alert us in your CV that you've had such specific training on wound pattern recognition for animals?
Other than I've passed my board exams and have practiced for 40 years.
Have you provided a list of cases where you have testified in court specifically about wound pattern recognition of dog bites?
I don't know if I have given a list. I don't keep those kinds of lists.
You mentioned one case about law enforcement dogs in federal court. When was that case?
I love her.
Several years ago.
How long would you say, if you had a guess?
How long was it ago?
Yes, please.
A couple years, around COVID time.
Did you testify in that case about law enforcement police dogs?
I testified about an individual who had injuries, and there was a question as to whether Canine Caper, who was the dog's name, inflicted any injuries on this person.
Canine Caper.
And this was in Boston federal court?
Springfield, yeah, Boston, right.
Is there a difference between law enforcement dog bites and domestic dog bites?
They have the same kind of dog jaw.
So you would say
They're taught differently, obviously.
would the wound pattern recognition be the same or different if you were looking at it from a law enforcement dog perspective or a domestic dog perspective?
The dog would be the same.
Do you have any other cases that you've testified about wound pattern recognition relative to dog bites?
I've testified in hundreds of cases. I can't say that I remember any particular ones.
Would you be able to identify any of those for us today?
No, too many.
I'll ask you about accident reconstruction experience. And I mean this respectfully. You don't have a biomechanical or a biomedical engineering type background, do you?
No, I'm not a mechanical engineer.
You're not certified by ACTAR or any of those type of organizations, are you, doctor?
No, I relate the injuries on the body to the motor vehicle.
Have you ever been to a car collision scene and investigated a car collision scene firsthand?
Yes.
And when you've done that, do you have a chance to look at all of the physical materials, the properties?
Well, when I go to a scene of a motor vehicle fatality, I look at the pieces that are scattered around. I look at the body. I look at blood stain patterns. I look at damage to the car. And then the body would go back for the examination at the medical examiner's office. And there would be further examination of the scene by accident reconstructionists and examination of the automobile by specialists who could figure out what motor vehicles do. So it's a part of correlating the injuries to the vehicle.
You've never written an accident reconstruction report yourself, have you?
No, that's not what I do.
I understand. In this case, what materials did you look at? Because I don't think in your report it mentions the materials that you studied. What materials did you study as the basis for any potential opinions regarding accident reconstruction?
Right.
Well, so you would like for me to tell you everything I studied in this case?
Yes,
I have my list here. Should I read?
that's fine
from
by
that?
me.
Okay. I studied the autopsy report, neuropathology report, toxicology, and associated paperwork from the medical examiner's office. I studied 104 autopsy and neuropathology photographs, 70 additional autopsy photos taken by Trooper Watson. I studied Mr. O'Keefe's medical records from the Canton Fire Department and EMS run sheet. I studied the Good Samaritan medical records that also included 35 photographs of the body. I looked at evidence of Mr. O'Keefe's clothing, blue jeans, t-shirt, sweatshirt, boxers, and sneakers. I'm sorry. I looked at photographs that were taken at the crime lab of various pieces of plastic, black, red, and clear. I studied photographs of the outside of Ms. Reed's SUV as it was parked at the police garage. I studied the Canton Police report, incident report, about 100 photographs taken by Canton Police of the outside scene. So that gave me a very good idea of what happened to Mr. O'Keefe.
Were you involved in a case, Commonwealth versus Daniel Tompkins?
Remind me about that. I've been involved in hundreds of cases.
Yes, you have. This case was in Franklin County Superior Court. It was a case where you had an opportunity to present testimony and regarding blood spatter, which you've been qualified expert for. And that, I'm sorry.
Well, that doesn't quite say what I did, but I remember the case you're talking about.
Did you attempt, or was there an attempt to have you qualified to talk about accident reconstruction in that case?
No, I'm not an accident reconstructionist.
And do you remember whether or not there was an attempt that was denied to try to have you talk about accident reconstruction in that case?
I have no idea. I'm not an accident reconstructionist.
Okay. Do you have anything on your CV specifically that offers any background on accident reconstruction or accident reconstruction type classes or seminars?
I don't think so.
I'm not an accident reconstructionist.
All right. Thank you, Dr. Lapasada.
No, you're welcome.
You can
So
tell.
can I just ask Dr.
cases, always been his legs.
Lapasada, about, you said you've been involved in autopsies with dog bites.
Yes.
How many?
I've done thousands of cases, probably 50 or so. It's not always the cause of death. And then I've supervised maybe 75 more where that dog bites were involved in the case.
When was the last one?
Let's see, probably 2 years ago.
Okay. Any questions based on my questions? All right. You are all set and asked you to step down, Dr. Lapasada. We'll get to you sometime this afternoon.
Thank you, Your Honor.
I do want to give everybody a break, including counsel. Can we do less than 5-minute arguments on this?
Easily. Yes.
John, I'll make this very brief.
Okay.
Dr. Llama is eminently qualified to speak to both the issue of wound pattern recognition as it relates to dog bites, specifically, as well as cause and manner of death as it relates to vehicle pedestrian incidents or impacts. The doctor has an incredibly impressive resume, just a touch of which we reviewed during the course of this voir dire for her qualifications. But with regard to the dog bite specifically, she talked about the differential diagnosis that she undertakes and undertook in this case. She talks about the inferential thinking that she undertook in this case. She talks about how that is the proper methodology in the scientific community and specific to the forensic pathology community in order to come to a determination about wounds and the source of wounds, i.e., was it a dog? Was it another animal? Was it another source? Was it lacerations versus abrasions, things of that nature? She's obviously done, as she indicated, thousands, if not climbing real close to 10,000 autopsies that she's either supervised or that she's conducted herself. She actually has, notably, as per the court's last question, she's actually undertaken personally somewhere close to, I thought it was probably 5 autopsies herself dealing with dog bites. They're not always the cause of death, but sometimes it's attendant to the injuries that led to a different cause of death. But she's undertaken at least 50, or that's what she estimates, 50 of those autopsies herself. She's seen dog bites, she's seen dog wounds, she engages in pattern recognition. She also teaches classes on pattern recognition as it pertains to dog bites, and she's eminently qualified to speak to that in this particular case. She has been able to come to an opinion and conclusion as to whether or not the injuries to John O'Keefe's arm are consistent or inconsistent with dog bites, and I expect that she would then give that opinion and conclusion to a reasonable degree of medical certainty and to a reasonable degree of scientific certainty. As it relates to her differential diagnosis and her ultimate conclusions concerning the automobile impact, obviously many more autopsies dealing with that because it's more common. She also engaged in the exact same differential diagnosis. She has training. The subfield of, or the sub-issue of vehicle pedestrian impacts is included and subsumed within much of the medical literature that she's been taught on, going all the way back to the 1980s, dealing with her boards, and she's consistently passed her boards. She's consistently kept up with the literature. She's consistently engaged in autopsies herself, so she has firsthand training. She also trains other medical professionals, other doctors, other medical examiners, and she supervises other medical examiners. She's been the chief medical examiner for an entire state. I cannot imagine somebody more eminently qualified to talk about the 2 subjects that she's been called to talk. Well, she's called to talk about several other subjects, but these 2 subjects that's before the bench right now, than somebody with Dr. Lapasada's qualifications. I will submit on the voir dire that we just completed.
All right, thank you. Mr. Brennan.
I do
Be
not
truthful,
think that
Brennan.
Dr. Lapasada has articulated the experience the way it's been summarized. She could not provide any specific training other than her boards and her references to literature. She could not articulate one single class or seminar that she took that pertained to differential diagnosis of dog bite injuries. She has no specific memory of having any type of experience in differential diagnosis as far as being in a training seminar or advanced education. She has the experience of a medical examiner who has seen what she believes to be dog bites in the past. She has no publications or references that she has studied the issue of differential diagnosis or pattern wound recognition relative to dog bites. If we look at the standard Dr. Russell employed, Dr. Lapasada does not have any of the merit to be an expert in dog bites. While she has taught, we did not hear about anything in particular that she has taught about specific pattern wound recognition analysis regarding dog bites. She is an experienced medical examiner, has a wealth of experience, past experience in autopsies, but she has no experience that is a basis for her as an expert in being a dog bite expert. Particularly, she mentions one case that she's testified in federal court that we've heard of today, and she has nothing whatsoever in her report or resume to establish that she has used, studied, and knows this methodology. In fact, her CV and her report don't have any basis for one to look at and see that she has any specific experience in dog bites. And so Dr. Lapasada, from the Commonwealth's perspective, should not be able to give an opinion regarding or about whether or not the wounds on Mr. O'Keefe were caused by a dog. She simply does not have the training and experience and education and methodology to be a
Seriously.
so-called dog bite expert. Regarding accident reconstruction, she said it best. She is not an accident reconstructionist. She saw some of the materials in this case, but it is a fraction of the materials in this case. She is not in a position to give an opinion whether or not the wounds are consistent with broken taillight. There's nothing we see on her CV. There's nothing we see in her report. There's nothing we heard on direct examination that she has any experience in breaking glass, breaking plastics, and the causation of wounds. It also overlooks the fact that the opinion that would be offered would extend beyond just the wounds on the arm. It would extend to a general opinion that he was not involved in a collision, and that's improper. There's no predicate or basis for it. And so based on her testimony and absence of being able to provide any education or experience, she should not be able to testify about either of these two matters.
Okay, thank you.
Briefly respond.
Okay.
She was, Mr. Brennan suggests that, well, she's only been qualified in one court, federal court. The federal
Louder.
judge that was handling that case qualified her as a dog bite expert in that case. That is not a small thing. That, as a matter of fact, it's a very big thing for Dr. LaPosada and her credentials. In addition, she indicated, contrary to what Mr. Brennan just suggested, she indicated that she has been training on wound pattern recognition as it pertains to dog bites for her entire career, not just when she was studying for her boards, since she's been studying for her boards. And it's been constant and consistent throughout her entire career. She's made these differential diagnoses. She's seen the autopsies. She's seen the wounds during autopsies firsthand, probably 50 or more. She's supervised another 75 or more autopsies dealing with known dog bite wounds. She has the credentials. The court will recall that, for instance, Dr. Isaac Wolf was called to testify by the Commonwealth. He had absolutely nothing, no credentials whatsoever to talk about wound pattern recognitions. He was a neurosurgeon, and yet he was allowed, over Mr. Alessi's objection, to talk about and to discuss his opinions and conclusions as to the wound pattern on the back of John O'Keefe's head. Certainly, Dr. LaPosada brings much, much, much more to the table than Dr. Isaac Wolf. I'm not comparing them. They're apples and oranges. Dr. LaPosada is she doesn't have to be a sole dog bite expert to be expert in dog bites. She doesn't have to be Dr. Russell. She just has to have that level of knowledge, that level of skill, that level of expertise that's beyond that of the average layperson in order to opine as an expert on a particular issue. She certainly brings that to the table as it pertains to dog bites. And I think her skill and her education, training, and background certainly speaks to the fact that she has that in spades with regard to motor vehicle pedestrian incidents.
All right. Thank you. All right, I'll get your ruling as soon as I can. So we're going to stop back up at 2:20, and I expect to go straight through the rest of the afternoon.
All right, for the court,
We're good,
please.
by the way, Terry. You're going to be just fine. Yeah, 2:20, which means 2:30. Before we transport everybody to midday missing, because we do have to go there quickly to be able to get those stories out in the same, time frame. It is so apparent that Brennan is shaken.
He's flustered.
And he knows it. He knows that he made a really, really big mistake, and you can just tell he doesn't have that, arrogance.
He's been knocked down a peg or two.
Yes, he has, for sure. And I think this
love it.
lady, I don't see how she's any different than Dr. Russell. They're like the same in my book, but she also seems very no nonsense as
She does.
well. She's very soft spoken and no nonsense. I think, who knows, maybe Brennan might do better now that he's a little bit more docile, instead of aggressive and cagey. I don't know. We'll see. We will see. I can see you're not allowing this. I don't see how though. I don't see how, but
I don't see how, because Bev to me is already getting very close to crossing a line of needing to be charged with whatever she can be charged with by not
I don't know if there is
allowing.
a thing.
I mean, there's got to be something for a judge who is very obviously biased if
Oh
they
yeah, they get
don't
off the
allow
bench.
the defense to put on their defense.
Yeah, I'm curious to see how he is when we come back. By the way, well, you know what? We'll talk about it when we come back. So here's what we're going to do. I'll save my thoughts for that because I'm sure we'll have some time to kill because they're never going to be on time anyway. So here's what we're going to do. I'm going to shoot you guys over to Midday Missing. Terry's going to cover some very, very important Washington State missing people's cases. Please watch her show. It's
Please.
really, really good. And then as soon as she's done, it'll put you right back into our afternoon episode. You don't even have to touch anything. Now, in case the portal doesn't send you there, it's subscribe. You can find it on this channel, the True Crime and Wine Time channel. So, but we will be back for the afternoon. So go get your snacks, blankets. Let's watch some stuff and spread the word about these missing people, shall we? All right. We'll see you guys on the other side. Bye.